Good morning, everyone. Welcome. You may notice that my voice is not exactly like it always is. I've had a little stopped-up nose for a few days, and for some reason, it's a little croakier. So I have been talking less, which has been met by great happiness here at the commission. But we're glad to have everybody here. We want to ask Mr. Stark to read the docket before we get going.
Thank you, Mr. Chairman. Mr. Chairman, other commissioners, we're here for the matter of docket number 2019-184-E, which concerns the South Carolina Energy Freedom Act proceeding to establish Dominion Energy South Carolina Incorporated standard offer, avoided cost methodologies, form contract power purchase agreements, commitment to sell forms, and any other terms or conditions necessary. This is pursuant to South Carolina Code Annotated Section 584120A. Mr. Chairman, this hearing is scheduled for October the 14th, 2019 at 9 a.m. in the office of the Commission at 101 Executive Center Drive, Columbia, South Carolina 29210. Mr. Chairman, the docket is in order.
Thank you. We'll take appearances. I'll just call the roll. Dominion Energy. And when we do this, everyone please remember to get to a microphone so that, because we are live streaming, and if you don't stand behind a microphone, nobody out there will hear you or know you're saying a word.
Good morning, Mr. Chairman, Mr. Vice Chairman, members of the Commission. My name is Chad Burgess. I'm in-house corporate counsel for Dominion Energy South Carolina. And with me today is Matthew Gissendaner. He's also in-house corporate counsel. We also have our two outside counsel with us today, Mr. Mitchell Willoughby from the law firm of Willoughby and Hafer, and Belton Ziegler from the law firm of Womble Bond Dickinson. It's a pleasure to appear before you today, and we appreciate the opportunity to present the company's case. Thank you.
Thank you. Welcome. Energy users.
Mr. Chairman, I'm Scott Elliott here on behalf of the energy users.
Thank you. Solar Business Alliance. Make sure that thing's on. Punch the button.
Right there. How about that?
Yeah, much better.
Yeah, Weston Adams with Nelson Mullins for the Solar Business Alliance and for Johnson Development. I've also got with me Jeremy Hodges of my firm is also representing the Solar Business Alliance and Johnson Development. I've also got Jamie Golden with my firm who's representing Johnson Development. Ben Snowden with Kilpatrick has been admitted pro hoc in this case. He's also representing the Solar Business Alliance. And Richard Witt of the Witt Law Firm is representing the Solar Business Alliance as well. Thank you, Mr.
Thank you.
Yes, sir.
Thank you. So, have we gotten everybody from Johnson Development or Mr. Golden, y'all? Okay. Thank you. Welcome. Welcome. Echoplexus.
Mr. Chairman, members of the Commission, I'm Richard Witt from the Witt Law Firm.
Thank you. Welcome, Mr. Witt. Walmart.
Your Honor, Carrie Grunman with Spillman Thomas and Battle on behalf of Walmart. We are here today solely in an observational capacity. Walmart won't have any cross-examination for witnesses, so I'll just be in the galley today.
Okay.
Thank you.
Thank you, ma'am. Southern Alliance for Clean Energy and Coastal Conservation League.
Good morning, Mr. Chairman. Excuse me, I have the same.
Sound like me.
Yeah. Members of the Commission, I'm Bland Holman with Southern Environmental Law Center on behalf of Southern Alliance for Clean Energy and Coastal Conservation League. And with me is Stinson Ferguson this morning and Lauren Bowen, who's been admitted pro hoc VG.
Thank you. Welcome. Office of Regulatory Staff.
Good morning, Mr. Chairman. Jeff Nelson, Jenny Pittman, and our Executive Director, and Annette Edwards are all here today on behalf of ORS.
Thank you. Welcome. Okay. Do we have any preliminary matters or concerns before we get going?
Mr. Chairman?
Yes, sir.
I appreciate you asking that question. I want to be very clear about something. I want to make sure that no one in this room has any reason to believe that these matters, or this particular matter going forward this week, would it be undermined, or the validity of the outcome would be subject to scrutiny due to any violation of commission rules, any violation of the canons of judicial conduct? Well, hearing none.
Thank you, Vice Chairman Williams. Okay, we have had requests for opening statements, and so I think, Dominion, you go first.
Thank you, Mr. Chairman, and may it please the Commission. My name is Matthew Gissendanner on behalf of Dominion Energy, South Carolina. Act 62 recognizes several ways for South Carolina to add solar energy. One way is under PURPA's must-purchase obligation. That's why we're here today. Under the must-purchase provision, a qualifying facility, or QF, may site a plant wherever it chooses, regardless of system need, and force the utility to buy its output. However, rates for such purchases must not exceed the utility's avoided cost. Dominion Energy South Carolina has signed contracts for over 1,000 megawatts of QF solar, well over 20% of the company's 5-year average retail peak demand. This significant amount of QF solar reflects the company's good faith and proven record. The Commission opened this docket to approve the methodology the company will use to calculate its avoided cost and to approve contracts for use with must-take purchases. The company submitted the following forms along with supporting testimony for approval: a standard offer, a form contract PPA, and a commitment to sell form. The ORS and its expert, Mr. Horry, found these forms commercially reasonable and consistent with PURPA and the Act. This is unsurprising given the company's record of signing QF contracts. The company also submitted its avoided cost methodology, the process it will use to calculate its avoided cost rate. As you know, purchases from QFs cannot exceed this rate. In developing its forms and methodology, the company had two key objectives: comply with Commission precedent and ensure ratepayers are protected as Act 62 requires. The General Assembly was crystal clear. It left no doubt that its focus and the focus of this Commission in evaluating the company's proposals is the customer. Specifically, it required that any decisions be just and reasonable to ratepayers and in the public interest. And while they should be non-discriminatory to small power producers, any decisions must strive to reduce the risk placed on the using and consuming public. The Act also requires that decisions be consistent with PURPA. PURPA regulations are quite clear that rates paid to QFs be just and reasonable to the consumer and in the public interest, and that the utility not pay more than its avoided cost for the purchases. It is important to keep in mind this express legislative intent now and throughout this proceeding. Solar QF developers at times obscure this intent and advocate for rates higher than avoided cost at longer fixed terms to help them obtain more advantageous financing and generate higher profits, while, as Ms. Chilton put it, just keeping the ratepayers in mind. But that is not what the law requires. Both Act 62 and PURPA protect customers, and one way they do is by ensuring the utility pays its avoided cost and only its avoided cost to QF developers. PURPA does not require a utility to pay QF developers energy and capacity as a matter of right. Rather, it's clear. Capacity payments are only warranted where the product is sufficiently reliable and has sufficient legally enforceable guarantees of deliverability to justify a capacity payment. In filed testimony, QF developers seek less enforceable guarantees. Company witness Hanslick will explain the company's actual experience regarding the operating reliability or lack thereof of QF solar. Recall the company's 2018 fuel case. There, this commission correctly found it reasonable to set avoided capacity cost at 0, noting that the company had had a dramatic change in circumstances with 865 megawatts of solar under contract, and that addition of another 100 megawatts of solar did not affect the company's future capacity needs. This commission further explained that a generating resource has to provide capacity in the winter as well as in the summer in order to avoid the need for capacity and thereby have capacity value, and that additional solar does not provide capacity during the winter period. That statement is as true today as the day you wrote it. So what has changed since May 2nd, 2018? For one, the company has continued to execute solar PPAs and now has contracts for over 1,000 megawatts of utility-scale solar scheduled to be in service in 2021. In other words, over the next 2 years, solar energy is scheduled to exceed 20% of the company's 5-year average retail peak demand. This means you must evaluate the company's methodology and form contracts just for this company. It also means that additional solar does nothing to help the company meet its winter demand. As you correctly recognized in 2018, additional solar does not provide capacity during the winter period. It was appropriate to set the avoided capacity cost at 0 in 2018, and it remains so today. Now, the Solar Business Alliance and Johnson Development push a very different narrative. They would have you believe that this commission is charged with helping developers obtain advantageous financing and generate higher profits with inflated avoided cost rates for long fixed terms while only keeping ratepayers in mind. Unlike the company, solar developers are not regulated. They don't regularly appear before you. They don't open their financial records up to you for annual inspections. In fact, it is not uncommon for solar developers to submit projects of 74.9 megawatts. This avoids commission review under the Siting Act, which applies to new generation above 75 megawatts. And they want you to just keep ratepayers in mind. Once you approve these forms and the company's methodology, the company must take the energy the QF can deliver. So it's important that you protect ratepayers and protect them in accordance with Act 62. Merely keeping customers in mind is not adequate, and it does not comply with the Act. In sum, this proceeding is not about Dominion Energy recovering an expense, and it's also not about just keeping the ratepayers in mind. This proceeding is about setting the amount of an expense that once incurred by Dominion Energy will be passed straight through to customers. The positions advanced by the SBA, JDA, and others parties in this docket ask you to ignore the clear mandates of Act 62 and PURPA and require the company to purchase from QFs at inflated avoided cost for longer terms to help developers obtain favorable financing and generate higher profits. If you adopt this approach, customers will not be protected, or for that matter, even kept in mind. They will be harmed. Dominion Energy respectfully requests that the Commission protect customers and issue an order approving its methodology and contract forms as set forth in its testimony. Thank you.
Thank you. Okay. Who wants to? Mr. Adams.
Chairman Weston Adams again for the Solar Business Alliance. I would point out that the title that the legislature chose to give to this act, the Energy Freedom Act, sent a message to the state and sent a message to this commission that the idea here is this is a new era. The monopolistic era of the investor-owned utilities should be over. And the act itself has an express provision calling for and encouraging renewable energy in a variety of different ways. So it is at least ironic that the proposal that Dominion put in fact, retards renewable energy in almost every way, every element of the proposal. So if you walk through the proposal step by step, every piece of the Dominion proposal, the evidence will show, is unreasonable and is violative of the Act. The price that they put forward for avoided costs for energy is unreasonable and is basically based upon erroneous assumptions and mistaken assumptions. Number two, the price that they put forward on a capacity valuation for avoided cost is also unreasonable and is not based upon any reasonable evidence. Number three, the integration charges, Mr. Chairman, the evidence will show that the integration charges that they propose are actually unreasonably high and, again, are violative of Act 62. Number four, the integration study that the Act itself says we should undertake, they basically ignored that and plowed right ahead with the integration charges. And I think the evidence will show that the integration charges that they proposed are unreasonably high. Mr. Chairman, the power purchase agreements, the forms that they proposed both for the standard offer and for the large size, large QF PPA, those forms are not reasonable as to their terms and are, again, violative of the intent of the Energy Freedom Act. Mr. Chairman, Dominion has submitted as part of their proposal a notice of commitment form with the intent of making that the way any QF establishes a legally enforceable obligation under PURPA. Well, the form that they put forward, again, is unreasonable and basically provides unreasonable obstacles to a QF and makes it so it would be effectively a violation of PURPA, the form that they've proposed. Finally, Mr. Chairman, the energy storage proposal, the Act itself says that it has particular provisions encouraging energy storage, and the proposal that they put forward basically doesn't do that. It doesn't have any reasonable proposal for energy storage. So if you consider all these elements of their proposal together, the constellation of all these things together, and look at that, it's unreasonable and not in line with the purpose of Act 62. The bottom line is this. It would be if the Energy Freedom Act was proposed in order to promote renewable energy, that's one of its express purposes. And at the end of all this, the proposal that Dominion put in is actually less favorable to renewable energy. We're going to be worse off as a renewable energy sector than we were before the Act. That would be an extremely unfortunate and ironic outcome. The state of South Carolina would notice that outcome if that's where we ended up. Thank you, Mr. Chairman.
Thank you. Mr. Golden.
Mr. Chairman, members of this commission, I rise on behalf of Johnson Development Associates out of Spartanburg, South Carolina. I want to start by giving you an overview of what has brought us to this point. Then I'd like to briefly hit upon what we are asking that you order based upon the evidence in this hearing. Finally, I'd like to summarize as what we see the direction and the future of electric energy production in this state as begun by this act and completed by you all here at the Commission. Our founder, George Dean Johnson, and our CEO, Jordy Johnson, both see the future of energy as being grounded in renewable energy. The first thing they each told me when beginning work upon this in 2018 was that they want to see South Carolina lead on this issue. We have an opportunity for our state to be a leader in something, and here we are. Those men are leaders, and they believe now is the right time for renewable energy in South Carolina. They believe that for two reasons. First, it makes sense from a ratepayer standpoint. Contrast that with the scare tactics you'll hear from Dominion. This is good for the ratepayer. It lowers cost. Solar, frankly, will lower cost, and the evidence will show that. Also, industrial customers, who are also ratepayers, Our businesses of this state demand it. You heard Bobby Hitt come before y'all and talk about clean energy as being a primary motivator for companies locating in this state. You're going to see and hear more on that from us during these proceedings. Second, we are going to have a void in generation in the coming years, and clean, renewable, cheap energy is the responsible way, in Johnson's mind, to fill that void. Johnson grew frustrated with the utilities' roadblocks to independent power producer development. The monopolistic utilities and their shareholders have a financial interest in assuring that developers are not able to access capital for financing projects, and the IOUs have been really darn good at making sure that happens. In our attempt to develop sustainable financing for development, we realized that a law change was necessary at the General Assembly, and we found a bipartisan appetite over there at the legislature. This bill passed 110-0 in the House and 46-0 in the Senate. There are no politics involved here. It's a mandate. They want more solar power and expect to see more solar power come online after it. Not a single dissenting vote was cast during the process, despite the lobbying efforts by the utilities against the bill. The South Carolina Energy Freedom Act gives this commission the power to decide the avoided cost rate from a range of inputs. It is implicit in Act 62 and explicit in there that we have a policy of encouraging renewable energy in this state. Therefore, you should pick the higher end of the range to comply with that goal. That will also protect the ratepayers, as solar has been shown to drive down energy costs. We also ask that you set terms of the power purchase agreements at greater than the minimum of 10 years. That's going to come up a lot, and you're going to understand why that's so important for protecting the ratepayers as a fuel hedge. Solar doesn't, there is no fuel cost variable there. And so we're going to ask you to set it between 15 and 20 years. One other piece that is particularly important to us is the Act has given you an amazing tool in the independent third-party expert. That expert has done a good job. We've seen their requests come across of asking the right questions. They're going to take the ranges. They're going to ask the questions, and then they're going to give you recommendations on how to comply with the Energy Freedom Act. Put simply, the interplay here between term and price is what we are coming for, and that's what you are going to be charged with determining. That is the key, but so is the component that allows for the range of calculations and inputs. You will see evidence of artificially low numbers produced by the utilities. You will see our numbers. The Energy Freedom Act instructs you for the very first time to pick rates in that range with the policy that promote renewable energy. The third party will check and verify. The interveners are going to put forth proposed rates. And again, we're going to ask you for terms of PPAs up to 20 years. Dominion incorrectly frames this as being about their ratepayers. They call them customers and implies choice. That's also not what the evidence will show. They will try to say that longer-term PPAs harm the customers or risk to customers. Again, customers implies choice, not there. The evidence will show that these longer-term PPAs actually protect customers. They protect customers from risks that natural gas prices are going to rise. All the risks that come with the utility's decision to build its own generation plant, cost overruns, delays, possibility the utility will invest billions in a project that's abandoned, all of those are not borne by the ratepayers from a QF development. QF contracts insulate ratepayers from all these risks. In sum, I'd like to give a little anecdote. Last night, as I was trying to unwind after preparing for this morning, I realized I had recorded on TV a series, a Ken Burns documentary on country music. Our friends at ETV put it on, and I don't know if any of y'all caught it. One of the episodes was entitled, "Are You Sure Hank Done It This Way?" And it was the installment on the 1970s flipping of the industry in Nashville. As I watched, I tried to doze off last night, and they got to the part of the episode where the title track's played by Waylon Jennings, all-time favorite singer of mine. And I listened to the lyrics, and it really struck a chord, almost ironic. It said, if you'll allow me, I won't sing it, but Lord, it's the same old tune, fiddle and guitar. Where do we take it from here? It's been the same way for years. We need a change. We do need a change, and the Energy Freedom Act is that change. We aren't outlaws. We went and changed the law. The establishment is fighting here for the status quo. We're going to change the industry for the better, just like those singers in the 70s did in the industry. We need a change. The evidence will show what is needed to accomplish that. The General Assembly is unanimously behind the interveners. They are watching and expect this proceeding to produce solar power development in South Carolina, which will lead to lower rates for all classes of customers, and we're here to effectuate that change. Thank you, Mr. Chairman and members.
Thank you, Mr. Golden, and thank you for not singing. Okay, who else has Mr. Holman?
Thank you, Mr. Chairman. You've got 3 legal poll stars going into this proceeding. First, you've heard a lot about the Energy Freedom Act. I think that there's no dispute that this act was passed to encourage more renewable energy, more competition. It strives, it calls upon you, gives you a lot of work to do, unfortunately. It's a very complicated statute. But it clearly was a sense of the General Assembly that something needed to change. There's the status quo. They pass a law with a lot of provisions that are governing this proceeding, and the only way to understand that is that they were trying to implement change. This was not an endorsement of the status quo. This was something new, and the provisions that call for more renewable energy are key to that. The second poll star is PURPA, the Public Utility Regulatory Policies Act. You've heard a lot about that. You've heard about it in the past. It was the purpose of PURPA is to promote competition and the downward pressure that puts on utility rates. Utilities don't like to talk about that fact of PURPA, but that is what courts have held is a purpose of PURPA. So it's pro-competition. The third poll star I would submit to you is Order 2018-322. That's your last avoided cost order with what was SC&G. And Mr. Gissendaner noted that and noted your findings in that. He did not note to you, but I assume you're aware that we have appealed that order to the state Supreme Court. So that order is under appeal currently. There's one thing we agreed with in your order there. You called upon the utility to aggressively pursue economic demand-side management and energy efficiency targeted at reducing the winter peak. You called on them to implement that because, as you'll recall, you'll hear a lot about now, what has happened is the utility in one of the hottest states in the country is now saying its big problem is winter peaking. And we have a very fierce disagreement with this utility about what can be done with that winter peak. Is it real, and what can be done to address it? Because if you address the winter peak, then solar's capacity value is incredibly clear. And so you directed them to implement changes to address the winter peak. And here we are, a year later, and as you'll hear, they haven't done it. So since your order, they haven't done what they're supposed to do. Your order is under appeal, and the General Assembly passed a brand new statute governing this proceeding. And I think, as you'll hear, the rates proposed by the utility are incorrect, they're inaccurate, and that at the conclusion of this hearing, we would submit that you should adopt rates that are accurate and that do compensate fairly these qualified facilities for their avoided costs and energy. Thank you.
Thank you. Any other opening statements? Okay. All right, before we call the first witness, let me just remind everybody while we're doing this, during cross-examination especially, we want everybody to talk not over each other. Ms. Tackett is a great court reporter, but she can't say two people's words at the same time. So if you jump in on top of each other when you get fired up over something, I'm going to call you down and make you say it over again. And so let's just start with that in mind. Okay. Dominion, call your first panel, please. Some of them are
Gentlemen, if you would raise your right hands, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Go ahead, Mr. Burgess.
Thank you, Mr. Chairman. I'll begin with you, Mr. Raftery. Would you please state your full name for the record?
John Howard Raftery.
And by whom were you employed and in what capacity?
I'm the Director of Rates and Regulatory Affairs for Dominion Energy, South Carolina.
And have you prepared or caused to be prepared under your direct supervision and pre-filed in this docket direct testimony consisting of 28 pages?
Yes, I have.
Are there any changes or corrections required of your direct testimony?
I do have a number of changes. As we will learn in a second, Mr. Danny Cassis will be adopting the testimony of Johnny Folsom, so I need to change some names in my testimony.
All right. Will you direct the commission and the other parties to the page number and line number where that change is required?
Yes, absolutely. So starting on page 4, line 4, there's a reference to Mr. Johnny Folsom Jr.
This is in the direct testimony?
Yes, sir. In my direct testimony, page 4, line 4, there's a Mr. John E. Folsom Jr., Power Marketing Manager. That should be Mr. Daniel F. Cassis, Vice President of Customer Relations and Renewables. Also on that page, line 7, Folsom should be replaced with Cassis. And on line 8, Folsom should be replaced by Cassis. Moving over to page 9, line 16, Folsom should be replaced with Cassis. Moving over to page 24, line 4, Folsom should be replaced with Cassis, as well as on page 26, line 4, Folsom should be replaced with Cassis. I have 2 additional edits going back to page 14. Line 7, there's a reference to 475 megawatts. That should be 550 megawatts. And lastly, on page 24, line 5, I reference South Carolina Code annotated section 584220A. That actually should be 584120A. Those are all the changes to my direct testimony.
All right, thank you, Mr. Raftery. With those changes you just described, if I ask you the same questions contained in your pre-filed direct testimony as corrected, would your answers be the same?
Yes, they would.
Mr. Chairman, at this time, we would move into the evidence of record, the corrected pre-filed direct testimony of John Raftery as if given orally from the stand.
Mr. Raftery's corrected pre-filed direct testimony will be entered into the record as though given orally from the stand.
Mr. Raftery, have you prepared a summary of your direct testimony?
Yes, I have.
Would you please deliver that at this time?
Yes, please. Good morning, Chairman Randall and members of the Commission. Earlier this year, the South Carolina General Assembly enacted Act Number 62. The act requires the Commission to establish each electrical utility standard offer, avoided cost methodologies, form contract power purchase agreements or PPAs, commitment to sell forms, and any other any other terms or conditions necessary to implement this section. The purpose of my testimony is to provide the Commission with background information regarding Act Number 62, the requirements of Section 584120A under consideration in this proceeding, and to support Dominion Energy South Carolina's or the company's requests regarding these issues. In enacting Act Number 62, the South Carolina General Assembly encouraged the development of renewable energy resources, such as solar generation, in a manner that is fair and balanced to all customers of all programs related to renewable energy and energy storage. The General Assembly also made clear that revenue recovery, cost allocation, and rate design of utilities should be just and reasonable. With respect to avoided costs, the goal of Act Number 62 is to establish methodologies for each electric utility that accurately determine the cost the utility avoids as a result of purchases it makes from a qualifying facility, or QF, under PURPA. The company's objective is to accurately calculate its avoided costs that are paid to QFs, including independent solar power producers, so that customers are not adversely impacted by these power purchases. A standard offer is a contract that contains an avoided cost rate paid to eligible QFs that are 2 megawatts in size or smaller. This standard offer agreement will be the PPA for small power producers up to 2 megawatts in size and will establish the rates as well as the terms and conditions for these purchases of energy by the company. Company witness Cassis will further explain the standard offer. Both PURPA regulations and South Carolina statutes define avoided costs as the incremental cost to an electric utility of electric energy or capacity or both, which but for the purchase from QFs, such utility would generate itself or purchase from another source. Energy costs are the variable costs associated with the production of energy or kilowatt hours. They represent the cost of fuel and some operating and maintenance expenses. Capacity costs are the costs associated with providing the capability to deliver energy. They consist primarily of the capital costs of facilities. PURPA specifically provides no rule regarding the sale and purchase of QF power shall provide for a rate which exceeds the incremental cost to the electric utility of alternative electric energy. As of August 8, 2019, 31 utility-scale solar facilities have interconnected with the company's system. They represent approximately 498 megawatts of solar generation. In total, approximately 5,389 megawatts of solar generation is either online or has taken steps to supply power to the company's system in the near future. By comparison, the entire company's generation fleet represents only 5,641 megawatts of generating capacity in the summer and 5,894 megawatts in the winter. According to the Smart Electric Power Alliance, of 494 utilities across the United States, in 2018, the company installed the 11th highest amount of solar in the nation. Equally impressive, the amount of solar that the company has interconnected as of July 31st, 2019 is over 598 megawatts, or approximately 14% of its 2014 to 2018 five-year average retail peak demand, which is 4,291 megawatts. The company also has another 550 megawatts under contract to be installed by the end of 2021, which represents over 25% of its 2014 to 2018 5-year average retail peak demand. In addition, according to the Energy Information Administration's Form EIA 861, through 2018, the state of South Carolina has more net energy metering installations than the combined total of North Carolina, Georgia, Kentucky, Tennessee, Alabama, and Mississippi. As Company Witness Bell will further discuss, without additional energy storage, resources, or capital improvements enabling existing plants to operate at lower minimum generation levels, the company will be unable to accommodate the 5,389 megawatts of solar that is anticipated to be installed on its system. That amount exceeds the company's system load. This will necessitate curtailing of the energy output of these solar facilities at many times because solar power doesn't help to serve the system's winter peaking needs. For most non-summer days, the system load peaks either before sunrise or after sunset, and thus solar provides no support for serving these peaks. In addition, because solar generation cannot be accurately forecasted, a solar facility's output is not necessarily responsive to the needs of the company's system. The additional energy from solar generation also causes the system to experience decreasing minimum loads between the morning and evening peaks. This creates operational problems in running the system, as system operators have to select resources that can follow the load. The company is also required to propose a form PPA in this proceeding. The form contract PPA that the company is proposing is similar to the standard offer, except that it is for use for qualifying small power production facilities that are not eligible for the standard offer. That is, QF facilities that are greater than 2 megawatts in size. The form contract PPA includes the required provisions for force majeure, indemnification, choice of venue, confidentiality provisions, and other such terms. If a QF wishes terms that differ from the form PPA as approved by the Commission, they are free to discuss different provisions with the company. Company Witness Cassis will further explain the form contract PPA. The company also proposes a commitment to sell form in this proceeding. A commitment to sell form is a form that can be delivered by a small power producer who is prepared to make a substantial commitment to sell its output to the electrical utility. This secures its rights to sell the output of its facility at the avoided costs and pursuant to the PPA then in effect. Company Witness Cassis will provide further information about the proposed commitment to sell form. In order number 2019-43H, the Commission determined that issues pertaining to avoided costs, variable integration costs, and updates to the values included in the net energy metering methodology should be bifurcated from the company's fuel cost proceeding held in April 2019. Based upon the Commission's ruling on the company's updated avoided costs, variable integration costs, and net energy metering methodology in this proceeding, the company proposes to calculate the difference between those costs and values and separately account for them as incremental costs. The company further proposes to adjust its fuel costs as part of its 2022E annual fuel cost review proceeding to account for these incremental costs. By adjusting the company's fuel costs in this manner, customers will not experience any immediate impact, and these amounts will be appropriately accounted for and trued up as contemplated by the Commission in order number 2019-43H. The company respectfully requests that the Commission approve the company's proposed standard offer, form contract PPA, notice of commitment to sell form, the other terms and conditions proposed by the company, and the company's proposed methodology to calculate avoided costs. The company also requests the Commission find that the company's proposal is consistent with the requirements of Act Number 62, is fair and reasonable in the public interest, and properly reflects the company's avoided costs so that customers are not burdened with subsidizing developers of solar generators. Finally, the company requests that it be authorized to separately account for as an incremental cost the differences in net energy metering values which were stayed pursuant to order number 2019-274 and be allowed to seek an appropriate adjustment for the differences in these costs and values in its 2020 2E annual fuel cost proceeding. This concludes the summary of my direct testimony.
Mr. Raftery, did you also prepare or cause to be prepared under your direct supervision and pre-filed in this docket rebuttal testimony consisting of 17 pages?
Yes, I did.
And are there any changes or corrections required of your rebuttal testimony?
I have one change.
All right, would you please direct the commission and the other parties to the page number and the line number where that change is required?
On page 7 of my rebuttal testimony, line 21, you'll see that 475 megawatts, which should represent 550. So change 475 to 550.
All right, are there any other changes or corrections required of your rebuttal testimony?
No, there are not.
And with that change, if I ask you the same questions contained in your pre-filed rebuttal testimony, would your answers be the same?
Yes, they would.
Mr. Chairman, at this time, we would move into the evidence of record, the pre-filed rebuttal testimony of John Raftery as corrected from the stand.
Mr. Raftery's pre-filed rebuttal testimony as corrected will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. Mr. Raftery, have you prepared a summary of your rebuttal testimony?
Yes, I have.
Would you please deliver that?
Yep. The purpose of my rebuttal testimony is to discuss the company's response to certain issues raised in number 1, the direct testimony of Mr. Brian Horry, filed on behalf of the South Carolina Office of Regulatory Staff. Number 2, the direct testimony of Mr. Derek Stenklick, filed on behalf of the South Carolina Coastal Conservation League and Southern Alliance for Clean Energy. Number 3, the direct testimony of Ms. Rebecca Chilton, filed on behalf of Johnson Development Associates, Incorporated. Number 4, the direct testimony of Mr. Hamilton Davis, filed on behalf of the South Carolina Solar Business Alliance, or SC SBA. And number 5, the direct testimony of Mr. Ed Burgess, filed on behalf of the SC SBA. In response to Mr. Horry's recommendations regarding technical workshops, the company believes the technical workshops should be conducted in conjunction with the integration study authorized by Act Number 62. In this way, the technical workshops regarding the integration charge can contribute to the integration study and provide stakeholder input that the Commission can use to evaluate issues raised in the study. While company witness Dr. Tanner will provide additional testimony responding to Mr. Stenklick's testimony, I note for the Commission that the company has conducted and completed an extensive investigation into the possibility of relying on additional demand response programs to reduce peak demand. Specifically, in Commission Docket Number 2019-239E, the company has filed a comprehensive potential study and demand-side management program analysis. That study and analysis determined that, absent sufficient saturation of advanced metering infrastructure on the company's system, no new demand response programs would be cost-effective over the 5-year planning timescale used for program planning. In response to Ms. Chilton, I note that the purpose of Act Number 62 is not to increase competition, but, as I stated in my direct testimony, to ensure that the development of renewable energy resources, such as solar generation, proceeds in a manner that is fair and balanced to all customers of all programs related to renewable energy and energy storage. By setting avoided costs on a fair and objective basis, the company will foster energy conservation through the development of renewable energy resources that are economically justified. At the same time, it will fulfill the clear legislative mandate of Act Number 62 that compensation paid for solar generation must not shift costs to customers. Ms. Chilton also suggests that the company has been sluggish in adopting renewable energy programs when nothing further could be from the truth. As I note in my direct testimony, the company, in fact, has an admirable record with respect to renewable energy resources, especially compared to other electric utilities in the Southeast and across the nation. In response to Mr. Davis, I disagree with his assessment of the goals of Act Number 62. While Act Number 62 has a number of provisions that provide a process by which independent power producers are compensated for the energy production, electric utility customers are neither required to subsidize the development of these renewable resources nor assume the risks associated with them. Accordingly, Act Number 62 requires the company to calculate its costs and establish its rates at just and reasonable levels so as to fairly compensate the independent power producers for the value of the resource they provide without unfairly or unnecessarily shifting costs or risks to the company's customers. I disagree with the SC SBA suggesting that business as usual has prevented solar development. Mr. Davis is clearly mistaken if he means to suggest the company has not been successful in working with solar developers to bring economically viable renewable projects to market. The company is a leader in the electric utility industry in the incorporation of renewable energy programs into its generation portfolio. In fact, the company has so much solar generation currently on its system that it does not derive a capacity benefit from additional solar generation. If Mr. Davis means that the South Carolina General Assembly decided to abandon its policy of protecting customers from subsidizing solar developers through rates that exceed the true costs of its utility system, then the language of the Act clearly contradicts this assertion. I also disagree with Mr. Davis' assertions regarding risk to ratepayers. Mr. Davis's unstated assumption is that adding solar will displace capacity that the company would otherwise add to its system to serve customers reliably. This is simply not the case. The company makes the decision to build additional resources when its existing resources do not provide sufficient capacity to reliably meet customers' peak demands. The Siting Act protects ratepayers with respect to the addition of new generation facilities. In the settlement agreement entered into between Dominion Energy Incorporated, SC&G, now Dominion Energy South Carolina, and the SC SBA in the 2017 merger docket, the company agreed not to procure or apply to certify a new generating resource with a nameplate capacity of more than 75 megawatts without first conducting a competitive all-source solicitation. This provision includes renewable resources and also requires that an independent evaluator evaluate the bidding process and report to the Commission regarding the transparency, completeness, and integrity of the bidding process and evaluation of the bids. In sum, important protections are in place to ensure the company's customers do not face the risk of unnecessary or non-economical capacity resources being added to the system. Mr. Davis suggests that the company will set avoided costs at a low level because it has a bias towards adding capital-intensive facilities whenever possible so as to increase its return to shareholders. Mr. Davis's unstated assumption is that additional solar generation will displace capacity that the company would otherwise add to its systems to be able to serve customers reliably. This is simply not the case. Solar does not contribute to meeting the company's peak capacity requirements. Furthermore, as discussed above, if new capacity is required, renewable power generators will have the ability to bid for that provision of the capacity. On the other hand, solar providers have an unregulated price incentive to seek the highest possible avoided costs in order to maximize their own returns for their investors, in stark contrast to the regulatory protections that customers have against the company constructing unneeded facilities. With respect to Mr. Davis's assertion that it is demonstrably false that the company is not incentivized to understate avoided costs, it appears that Mr. Davis does not understand my testimony or the Siting Act or is unfamiliar with the settlement agreement. First, the company's interests are consistent with Act Number 62 and PURPA, namely, ensuring that avoided costs are set appropriately so that the customers are economically indifferent to the choice of energy resources. Second, it is impossible for the company to reduce competition with solar providers by keeping avoided costs low because it will have to proceed through the competitive all-source solicitation and the Siting Act process if it becomes necessary to add more generation. Third, the company's avoided costs as set forth here reflect its true generation and peaking needs given the needs and operating realities of its system. In response to Mr. Burgess's assertions regarding the utility's underlying financial incentive, it is the company's obligation to establish an avoided cost amount that accurately reflects the company's generation and peaking needs. In direct contrast, solar developers have no such obligation. Rather, they have an incentive to establish artificially high avoided costs in order to maximize their own return. The Siting Act and the settlement agreement ensure that any addition of physical generation plants is prudent and necessary and is not done without considering whether available renewable energy resources may efficiently provide that needed capacity. This concludes a summary of my rebuttal testimony.
Thank you, Mr. Raftery. We'll let you take a little break, and we'll now turn to Mr. Cassis. Mr. Cassis, would you please state your full name for the record?
Yes, Daniel F. Cassis.
And by whom are you employed and in what capacity?
Dominion Energy, South Carolina.
Mr. Cassis, are you aware that John Folsom calls to be pre-filed direct testimony and exhibits consisting of 29 pages in this docket?
I am.
And have you read Mr. Folsom's pre-filed amended direct testimony as well as his exhibits?
I have.
And are you adopting the pre-filed direct testimony of Mr. Folsom that was submitted in this proceeding?
Yes, I am adopting his testimony.
Are there any changes or required of that pre-filed direct testimony?
No, there aren't.
If I ask you all the questions contained in Mr. Folsom's amended pre-filed direct testimony, would your answers be the same?
Yes.
Mr. Chairman, at this time, we would move into the evidence of record the pre-filed amended direct testimony of John Folsom as adopted from the stand by Mr. Cassis.
We will, Mr. Folsom's pre-filed amended direct testimony as adopted by Mr. Cassis will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. Mr. Cassis, there are 3 exhibits that were attached to Mr. Folsom's testimony. Those are amended exhibit JEF1, amended exhibit JEF2, and JEF3. Have you reviewed those exhibits?
I have.
Are you adopting those exhibits as your own in this docket?
I am.
Mr. Chairman, at this time, we would move into the record of evidence the amended exhibit identified as JEF1, the amended exhibit identified as JEF2, and there's a 3rd exhibit identified as JEF3, which has not been amended as part of Mr. Folsom's testimony. We would ask that those be included in the record and be marked as, I believe it would be hearing exhibit number 1.
Okay, the amended exhibit JEF1, amended exhibit JEF2, and exhibit number 3 will be entered as hearing exhibit number 1.
Thank you, Mr. Chairman. Mr. Cassis, have you prepared a summary of your direct testimony?
I have.
Would you please deliver that at this time?
Good morning, Chairman Randall and members of the Commission. I have adopted the direct testimony and exhibits of John E. Folsom as amended on September 20th, 2019 as my own. The amendments were made only to the form purchase power agreement and the standard offer contract to reflect a reduction in the development period credit support. Act 62 requires Dominion Energy South Carolina to submit for the Commission's approval a standard offer contract, a form power purchase agreement, and a commitment to sell form. As such, I have provided the following exhibits: the company's template form power purchase agreement, form PPA, the company's standard offer for QFs up to 2 megawatts AC, and the company's notice of commitment to sell form, the NOC form. In this proceeding, the Commission is setting rules that will determine the company's costs and form agreements that may be in place for many years to come. It should be noted that there are a limited amount of renewable resources that can be accommodated on the company's system under current technological and operating characteristics. Utilities and regulators alike can help promote the effective development and deployment of renewable resources by developing rules that allow viable projects to proceed to construction, discourage speculative projects, and provide flexibility to ensure that contracts are prudent for the entire term of the agreement. This not only helps energy developers, but it also protects the company's customers. Turning now to the exhibits, the company kept the form PPA largely consistent with its existing PPA, except the form PPA is no longer specific to any one type of renewable fuel source. Given that the company has used similar agreements in South Carolina over the last several years, the renewable industry in South Carolina has either executed a contract very familiar to the form PPA or become familiar with the concepts running throughout the form PPA. This form is largely the same as those executed PPAs that have been filed with and accepted by the Commission to date. The standard offer is very similar to the form PPA the company uses for other similar utility scale projects, but it is available for projects up to 2 megawatts AC, and it contains standard rates. Act 62 expands PURPA by making the standard offer available to QFs up to 2 megawatts AC, essentially a utility scale project. Therefore, the protections provided in the standard offer are necessary because the standard offer is essentially a contract executed by the company and put out to the market for all eligible QFs. The Notice of Commitment form, or NOC form, is built around the foundational principle that QFs must make a substantial commitment to deliver the electrical output of its facility before it can establish this type of binding relationship. The NOC form draws largely upon established legal enforceable obligation concepts in place in other states, as well as the company's institutional knowledge accumulated from experience in this arena. The NOC form touches upon issues such as site control, delivery periods, and delivery deadlines, as those provisions evidence substantial commitment and are important to prevent a developer from gaming the system by locking in rates for a speculative project. Finally, I note Mr. Horry, the ORS expert, found that these three forms are commercially reasonable. This concludes my summary.
Mr. Cassis, have you also prepared or caused to be prepared under your direct supervision and pre-filed in this docket rebuttal testimony consisting of 38 pages?
I have.
Are there any changes or corrections required of your rebuttal testimony?
There are no changes.
If I ask you all the questions contained in your pre-filed rebuttal testimony, would your answers be the same?
They would.
Mr. Chairman, at this time, we would move into the evidence of record, the pre-filed rebuttal testimony of Daniel Cassis as if given orally from the stand.
Mr. Cassis' pre-file rebuttal testimony will be entered into the record as though given orally from the stand.
Mr. Cassis, do you also have any exhibits attached to your rebuttal testimony?
No, I do not.
Mr. Cassis, are there any exhibits attached to your rebuttal testimony?
You have the three documents, yes.
Thank you.
Yes.
Are there any changes or corrections required of your rebuttal exhibits?
No changes.
Okay. Mr. Chairman, at this time, we would move into the evidence of record, the pre-filed rebuttal exhibits of Daniel Cassis, and those are identified as DFK1, DFK2, and DFK3, and ask that they be marked and included in the record as hearing exhibit number 2.
Mr. Cassis, exhibits DFK1, DFK2, and DFK3 will be entered as exhibit number 2.
Mr. Cassis, have you prepared a summary of your rebuttal testimony?
I have.
Would you please deliver that at this time?
In my rebuttal testimony, I first address Mr. Horry's question regarding Section 8 of the Notice of Commitment form regarding additional facilities and whether liquidated damages or other payments will be made to the QF. Section 8 of the NOC provides a QF with assurance that if the company has not constructed the facilities necessary to provide interconnection service to the QF, the 365-day time period will be extended so that the NOC form will not terminate. No liquidated damages will be imposed on either party as a result of such extension. Mr. Horry also requests that the company clarify certain items in a notice of commitment form, Form PPA, and standard offer. The company addressed each of Mr. Horry's requests and made corresponding clarifying edits. For example, the company replaced a couple of references to SCANA SCNG with references to Dominion Energy, South Carolina. These changes are reflected in the exhibits filed with my rebuttal testimony. I also responded to Mr. Lawyer's recommendation to add language that clarifies each party's liability upon execution of a legally enforceable obligation, LEO. I explain that such a clarification to the notice of commitment form is not necessary because the parties will execute a PPA within a reasonable time after submission to the notice of commitment form, and the PPA contains such detailed language. I further testify about the Federal Energy Regulatory Commission's, the FERC, Notice of Proposed Rulemaking, NOPR, to reform PURPA. I addressed FERC's NOPR in response to Ms. Chilton's claim that the PURPA requires avoided cost rates and lengths of term sufficient for a QF to obtain regularly available financing that drives parity with the utility while keeping ratepayers in mind. I clarify that PURPA and Act 62 seek to protect ratepayers from unnecessary cost and not merely keeping ratepayers in mind. Additionally, I explain that the FERC examined industry data regarding independent generation development. Based on the data it examined, FERC found: 1, avoided cost rates have typically exceeded actual incremental costs, which mean overpayments have been made to developers, and in turn, customers have overpaid. 2, based on the increase in QF and non-QF generation, QF and non-QF renewables have access to financing. And 3, contract term lengths have decreased due to the risk that avoided costs will exceed actual avoided costs, contrary to PURPA. I also respond to Mr. Levitas' concerns regarding certain commercial terms contained in the company's Form PPA and standard offer. I note in my testimony that the commercial provisions he expresses concern about have been included in various PPAs in the past that have been submitted to and accepted by the Commission. Furthermore, ORS expert Mr. Horry found that the provisions in the standard offer and Form PPA are generally commercially reasonable and conform to industry standards. I addressed each of Mr. Levitas' issues and explained if the company accepted his proposal, and if not, the rationale for not accepting. I also addressed certain policy statements. Additionally, I responded to Mr. Levitas' limited challenges to the notice of commitment form. As the company has consistently explained, in order to establish a non-contractual LEO, a QF must evidence its substantial commitment to the project. In accordance with this, the company requires a QF to provide certain objective indications such as land use approvals, environmental permits, and the like. FERC has indicated its support for criteria such as this, which makes a QF demonstrate its commercial viability and financial commitment in order to establish a LEO. I further explain that the company properly included a provision to prevent a QF that fails to perform under the notice of commitment form from receiving fixed rates for a period of 2 years. This provision is required in order to deter QFs from establishing a LEO through the NOC form and then using the form or then refusing to perform as so they submit a second NOC form, establish a LEO, and take advantage of rising avoided rate costs. This concludes the summary of my rebuttal testimony.
Thank you, Mr. Cassis. Mr. Chairman, this panel is available for cross-examination by the other parties of record as well as any questions of the commission.
Thank you. Okay, we'll go to cross-examination. Mr. Elliott. Solar Business Alliance.
Yes, sir, Mr. Chairman.
Mr. Adams.
Thank you, Mr. Chairman. Mr. Cassis, I just have a few questions for you. I will be brief, I promise. The NOPR that you referenced throughout your rebuttal testimony, what does that stand for?
It's a notice of proposed rulemaking.
And that, therefore, that is not a final rule, that's a proposed rule, correct?
That's right. I never referenced the actual rule. I said it was the findings.
Right. So effectively, that is not a binding regulation.
No, I just referenced the findings, right.
Right. So, and the findings, which are being turned into a proposed rule, will be changed by public comment, correct?
You'll have an opportunity, obviously, parties will have an opportunity to make their comments. It won't change, I think, the initial findings, though.
Sure. In addition to the public comment changes, there is a great likelihood of litigation over the NOPR, almost certainty, correct?
I'm an engineer, not a lawyer.
You may be thankful, after we drag you through a few days of this, you might be thankful that. So my point there simply is, if between the likely litigation and between the public comment process, the great likelihood is that this rule will not be adopted as a final rule in this 4-year Trump term, correct?
Again, all I said during my testimony was the findings. I wanted to emphasize those findings, which I think were clear, and I have those in my testimony.
Mr. Cassis, throughout the direct testimony and the rebuttal testimony, there are a number of places where you reference legal points, either state or federal law legal points, correct?
That's correct.
I'll give you an example. You state that on page 6, lines 17 through 20, you state your view as to what the policies behind PURPA are, correct?
Correct.
Another example, as to the LEO, page 21, lines 1 through 7, you state your explanation of what is a LEO, what is that all about, correct?
That's right.
And then likewise, a third example and a final example, page 24, lines 16 through 19, you go into great detail about the LEO standards for both Idaho and Texas, correct?
That's correct.
Are you admitted to practice law in Idaho or Texas?
I think I already admitted I'm only an engineer.
Yeah, that's good. Again, you might be thankful that you're not. 2 other questions, Mr. Cassis. Since the current rates were approved in May of 2018, how many PPAs have been executed?
I think Mr. Raftery's got the detail.
Looking for a number.
Okay, I'll give you the simple number. There are 498 megawatts of contracts that are actually connected or interconnected to our system. There are another 550. So if you took those that have PPAs, so if you took those two together, this is where I'm good, the math, that gives you 1048 megawatts total on a system that the 5-year system average peak is about 4,300. So that would be about 25% of the system, 5-year system average is connected and would ultimately at the end of 20 be connected, or early 21. That's how much solar we would have on our system.
Okay. And again, I'm not an engineer, right? So you're going to help me out here. So really the question is how many PPAs since the rate change in May of 2018? Do you have a number of PPAs? Is it 2, 6, 8?
I don't have the spreadsheet in front of me, but I'm the signature on all those documents.
Right.
So, You know, I know we signed, I think of them in terms of tranches. So we've signed, the last set of contracts, I think, were in 18. We did sign contracts, I believe, in 18.
Would that be 1 or 50? I mean, how many contracts are we talking about since the rate change in May of 2018?
I do not remember the exact number.
Make a rough estimate?
I hate to lean on my comrade, Mr. Raftery, but he probably remembers, since he takes them over actually to the commission, which we file them and they accept here.
Mr. Rafferty, you have any idea of a number?
He leaned on the wrong guy. No, I don't. As Mr. Cassis has mentioned, I mean, my testimony, I mentioned we have 498 megawatts interconnected. I know this. I'm getting to your answer the best I can. 550 megawatts under contract. I don't know how many of those were signed after the fuel proceeding in 2018 that you're asking.
The question is simply this: is the number of PPAs less since that May 8, 2018 date than the number of PPAs you did in the 2 years prior to that, or the 4 years prior to that? Has there been a decrease in the number of PPAs executed is the question.
Yeah, and I can answer that, yeah. I think because as you integrate more and more resource, this is an engineering concept, but it actually drives the value of the resource down. And I'm not the resource planner, but I think that's intuitive.
So the answer would be yes, there has been a reduction in the number.
Yeah, that's correct.
Mr. Chairman, I've got nothing further. Thank you.
Thank you. Okay. Before we go with Mr. Golden, we're going to take about a 10-minute break. We'll be back. Okay, Mr. Golden.
I don't think I wanted that up there. Belton, is this yours? Oh, it should be up. No, you click the button, the black. Must have hit it. We good? Okay. Mr. Chairman, thank you. Mr. Rafferty, Jamie Golden from Nelson Mullins. I represent Johnson Development Associates in this proceeding, and I have several questions for you. You've been with SCANA Dominion since 2003, correct?
Yes.
And you've been with the company through the enactment of the Base Load Review Act, correct?
I think that was 2005, yes.
Okay. And the attempted constructions of Units 2 and 3 at VC Summer.
I had nothing to do with that, but yes, I was with the company during that period.
You were with SCANA during that period?
Yes, I was with the company during that period.
Thank you. And the following abandonment as well, you were with the company as well then, right?
I had nothing to do with nuclear, but I was with the company at that time, yes.
Mr. Rafferty, my question wasn't if you had anything to do with nuclear, it was whether you were actually with the company then. So a yes or no will suffice for a lot of these.
Yes, I did answer that. You're right.
Thank you. You testified that you attended numerous committee and subcommittee meetings on the Energy Freedom Act. Isn't that correct?
Yes, I saw you there.
We saw a lot of each other there. And you agree that a lot of time and effort went into the passage of that Energy Freedom Act. Wouldn't you agree with that?
Yes, including several years that you weren't there.
So were you lobbying on behalf of that?
No, I wasn't. I was
Didn't
there
think
to
you
give
were.
a voice
And-
for, I'm sorry.
Do you agree that Act 62 applies to Dominion Energy, correct?
Yes, it does.
And you concede in your testimony that Act 62 specifically encourages filings by the company to foster renewable energy.
I don't believe foster is used in the act, but it is there to encourage renewables with consideration for customer impact.
Okay, but on page 6 of your testimony, if you said that it was part of the act to promote renewable energy, you would not take that statement back from your direct testimony, would you?
I would not. If you looked at the act, the word promote is used in 3 places, whereas customers are used 112 places.
It's funny you talk about customers, given your history. Wouldn't you agree that the current proposal by Dominion will not expressly encourage investment in renewable energy?
The act sets forth very clearly that the utility is obligated, as it is under PURPA, to put forth accurate avoided costs, those rates for which the customers would have paid if the utility had generated and delivered that energy.
Mr. Rafferty, that wasn't my question. I'm going to repeat it again. Wouldn't you agree that the current proposal by Dominion Energy will not expressly encourage investment in renewable energy?
I don't know if the current avoided cost rates will expressly encourage renewables. I do not know the market for renewables, and I don't know if you or your clients can sign at those accurate avoided cost rates. So I can't answer that question.
And you determine accurate in your own opinion, correct?
Absolutely not. I don't calculate them. That's witness kneeling.
Okay, all right. Isn't it also true, though, you do talk about Act 62, and nowhere in that act is it mentioned that low avoided costs protect ratepayers?
I don't believe I've ever read that in the act. Yes,
Thank you.
You are correct.
The act talks about just and reasonable rates, correct?
Fair and balanced, just and reasonable are some of the terms that expressly describes avoided costs.
And you would agree that Dominion's proposal here looks almost identical to what was filed previous to the enactment of the Energy Freedom Act?
Filed in what docket?
Well, you proposed it in 2018, and now we've actually got rates that are worse, lower. We'll call them lower. I won't characterize them. Would you agree with that?
On a per megawatt hour basis, the numbers are lower, but things have changed since we filed them in 2018 or 2019. The system is different, and the number of projects we have under contract, I believe, are different. So it's not apples to apples.
Right. You abandoned a nuclear plant, correct?
Personally, I did not.
Your company, though, that you're a corporate witness for, correct?
Yes.
Thank you. So if Dominion's proposed rates are approved, you certainly wouldn't expect to see any more PPAs coming on, right?
I'm sorry. Repeat that question one.
Glad to. If Dominion's proposed rates are approved, you certainly wouldn't expect to see more companies than in previous times requesting PPAs.
No, I could not agree with that statement. I don't know the panel prices, the price decline, the ITC is still in place. I don't know the financial metrics that would indicate that there should be more power purchase agreements or less power purchase agreements.
Aren't there a majority of projects in the numbers that y'all keep referencing, and I know you corrected them a little bit earlier, but that have an interconnection agreement and a PPA, and that number of megawatts under contract, aren't there a majority of those subject to a variable integration charge?
I believe of the 1,048 megawatts under contract, about 700 megawatts have the variable integration charge that both parties agreed to.
So can we call it 70, 67%? You're a math guy, I'm not a lawyer, as we've all joked about up here.
Danny's the math guy. Amongst friends, we can agree, yes, 70% is fine.
Okay, let's call it 70%. Could you clarify how the VIC charge works in a proposed contract?
Sure. So I believe Danny has this in his testimony as well, but the variable integration charge is a clause that we just determined is in 70% of the contracts. Both parties agreed to this clause, and it roughly says to the extent that the seller, which is the solar developer, causes incremental system impact, that the seller is obligated to pay that instead of the customers. That is very loosely what that section of the clause says. And I know it was in my testimony from the fuel proceeding this year and last year. I'm not sure if it's explicitly in anyone's testimony this year.
Okay, thank you. So you would agree, though, that it's possible if this commission approves Dominion's proposed integration charge, that some of those projects would terminate their PPA?
I have no idea that would be the case. No, I don't.
No idea?
No, why do you think I would? No.
Well, you've offered yourself out and talked about integration charge and what makes projects work.
I don't know the financial metrics on the solar developer side.
But the status quo is that the companies don't owe a specific charge for liquidated damages in a PPA right now, correct?
I did not sponsor any testimony that talks specifically to liquidated damages.
Okay. All right. So all right, that's fair enough. I'll save that for Mr. Cassis. By its nature, you would agree that a variable integration charge, if adopted, does not promote renewable energy development by independent power producers.
I think it is a customer protection clause. Whether or not it promotes renewables, I don't know.
Okay. And as someone who spent so much time involved in the legislative process, you would agree that such a waste of time by not getting more solar is not likely to sit well with that General Assembly, correct?
You are more familiar with the General Assembly than I have because you've served there. I can tell you in my
I've not served. I've not served.
Well, a staff member. So, I can tell you, you asked about my involvement in those proceedings with the House, Labor, Commerce, and Industry, or the Senate Judiciary. It was there to convey to the staff members and the representatives and the senators what solar meant to the utility, the challenges it provided. It also wanted to get the facts straight that many people don't understand, specifically for Dominion Energy South Carolina, how much solar we have on the system. There's so much attention to North Carolina or Georgia or other areas. I think it's very instructive in my testimony to know that we were the 11th highest utility out of 494 across the nation to install solar in 2018. The state of South Carolina has more net energy metering systems than North Carolina, Georgia, Kentucky, Tennessee, Alabama, and Mississippi. I think that is, those are facts, and it was important for me and others to go to those meetings to make sure that the General Assembly understood that information.
You told those facts to the legislators, didn't you?
To the extent, yes, I could, absolutely.
They still passed Act 62 to apply to y'all, correct?
And if you looked at Act 62...
It's a yes or no question, John.
And y'all need to quit jumping on top of each other's talk, okay? I know it makes good worldwide viewing, but we need to talk one at a time.
Could you repeat the question?
You had an objection. Sustain, we'll do.
The
You filed testimony that Act 62 requires independent power producers like Johnson Development to be properly compensated for the energy they produce, correct?
On accurately calculated avoided costs, yes.
Thank you. And you acknowledge that the Dominion is not proposing to compensate producers for any capacity value they provide, correct?
Correct.
Okay. And you also expressly agree that Act 62 requires accuracy and transparency in avoided cost filings by the company.
Yes, I agree.
Thank you. And you would acknowledge that ORS found numerous inaccuracies in the company's filings, correct?
No, I don't. But they did find one issue that the company corrected, but I would not say numerous. No, I'm aware of one.
Okay. And Dominion's current proposal will not encourage investment in renewable energy, as we talked about, will it?
As I stated then, I don't agree with that statement.
Okay. If the utility was faced with a range of just and reasonable inputs for avoided cost calculation numbers, that would either result in lower or higher avoided cost. Wouldn't it be discriminatory, again, we're getting back to the language of Act 62, discriminatory against a small power producer if the higher range of that avoided cost was ignored?
The company did not put forth a range of estimates. The company put forth a number. So the question doesn't mean anything to me. We put forth an avoided cost number, both energy and capacity. There is no range.
But others have.
And we disagree with those, as our company experts will testify.
But you do agree there is a range provided will be a range provided in these proceedings?
Not by the company, no.
Okay, I agree, but by all parties here today?
No, I don't know if all parties are providing a range.
But you've read testimony where people that parties have proposed
I don't
ranges,
believe,
correct?
Yes, I have read other testimony, but I don't believe Mr. Horry, for example, provided a range. I could be wrong. I just don't know.
Mr. Burgess. Microphone.
Mr. Chairman, Mr. Golden has asked the same question 2 and 3, maybe 4 times of Mr. Rafter. He's answered it, and I would ask that this commission sustain the objection and ask that Mr. Golden move on to his next question.
Okay. I'm going to sustain that. Let's keep moving. We've gotten that answer, I think.
Yes, sir, Mr. Chairman. You would agree that the congressional intent behind PURPA was in part to inject competition into the monopoly markets, wouldn't you?
Yeah, I think there have been some appeals, if that's the term. Like Danny, I'm not an attorney, but I understand there have been some appeals where there's been the discussion of competition, but I'm not aware of the word competition used in PURPA itself.
Okay. Wasn't it the intent of that Congress to protect consumers and the U.S. economy against volatility in fuel price?
I don't know if I could agree with that statement exactly. I understand generally what was going on in 1978 and some of the general intent behind PURPA about energy independence, foreign dependence on oil, and things of that such. But if you want me to agree to the way that you've structured the sentence exactly, I'm going to say, no, I can't. So I don't know.
Okay, but your direct testimony does at least acknowledge that fuel volatility was a consideration of PURPA.
I'm not sure if it was fuel volatility as much as it was the constrained access to fuel.
And I don't want to put words in your mouth. So
I appreciate that.
That is, okay. But your testimony does cite to the Joint Committee report released when PURPA was enacted, correct?
One more time, Mr. Golden, please.
Absolutely. Your testimony, as you've filed it and submitted here today, cites to the Joint Committee report released when Congress passed PURPA, correct?
I believe it does, yes.
Okay. So you would you would agree that the report concludes that the congressional intent behind PURPA was in part to control antitrust in a monopoly market?
You are asking me things that would be better suited for an attorney. I could not answer anything about antitrust with PURPA. I'm sorry.
Okay, but you did allude to at least that joint report, correct?
I'm sure it's in my testimony. Yes, it's cited there under different contexts. I don't remember talking about antitrust.
Okay, all right. But that joint report implicitly applies to that.
Okay.
All right, thank you.
Is it?
And you've testified that you have concerns with PURPA, correct?
No, I don't believe I said I had concerns with PURPA. As Danny had indicated earlier, PURPA just within the last couple of weeks came out with a number of findings, and the notice of proposed ruling is based off of those findings. I don't understand or believe that those findings to change, but the rule might.
Sure. And there are a lot of proposals, as we talked about in the legislative process, that are proposed and never get enacted, right?
I don't recall talking to you about those, no.
No, not that we've discussed, that you've witnessed in your time participating in the legislative process.
Yeah, sure, there have been some renewable bills introduced that were not passed, yes.
There were bills that would have banned compensation for executives on abandoned power plants as well, correct?
I'm not familiar with that.
Okay. But if I said there were, I mean, you'd have no reason to dispute that, correct?
I dispute a lot that you say, but no.
Not that specifically?
I don't know.
Okay. You expressed concern for ratepayer risk from QF projects, but not from company-built projects, correct?
I did not make any reference to company-built projects.
In your entire filing of your direct or rebuttal testimony?
Company-built facilities? No.
Utility-built and owned generating facilities?
No, I did not make any representation to utility-built and owned.
Okay. But you expressed concern for ratepayers for QF-built independent power projects.
I think you might be confused. In my testimony, I referred to utility scale, which just indicates the size.
I don't think I'm confused, but I'll take your word on it. It would have happened before. Wouldn't be the first time. Your prices when you all go to build your own facilities, you base those on the projections just like anybody else, correct?
Dominion Energy South Carolina owns one solar facility. That is Boeing. You might get us confused with Duke and what they have, but Dominion Energy South Carolina only owns one facility. So if you're asking me questions, as you have, about project economics and decision factors, that's not something I do or have done.
Okay, and that's a good answer, but I'm not just talking about solar facilities here.
Okay.
When you go to build a power plant, you base them on the projections best available to your ability at that time, correct?
Certainly, yes.
Okay. And you look at construction cost, you look at fuel prices, correct?
I have not been involved, but that's absolutely what I expect to happen, yes.
Okay. And you would expect then that there would be a factor in the cost of any reserves the plant will require when you make that decision, correct?
You're asking an inexperienced person to answer that question. I believe the answer is yes, but I don't know.
Okay. And you take same projections, essentially, when you calculate avoided cost, correct?
We take into consideration the same what? Inputs?
Yes. Projections, you base them on the knowledge that you see as your projections.
Yes, the company has a number of different inputs into calculating the avoided costs. Several of those are projections. The one that I understand is contested is the amount of operating reserves. I'm not aware of any other inputs that you or your client or other interveners have proposed that are inaccurate.
Okay. There's also, though, a possibility that avoided costs, just like any other fuel cost, the avoided cost could rise, correct?
Avoided costs could rise, yes.
Okay. So locking in rates today would actually protect as a hedge against that, correct?
History has demonstrated the opposite of that, but yes, it's possible.
History has also demonstrated that we're at a historic low for natural gas, correct?
I do not forecast natural gas. Company witness Mr. Neely could answer your questions better. I do understand that natural gas prices are at a low, yes.
And you would agree that natural gas prices are a consideration and a driver of avoided cost calculations?
I understand that is an input, yes.
So it would reason that if they're at an all-time low, they're only likely to rise. And I mean,
I don't know if they're at an all-time low.
Okay. We'll ask Mr. Neely about that. No problem. Mr. Rafty, you believe that the Siting Act protects ratepayers from all risk?
It is, I'm not sure it's able to prevent ratepayers from all risks, but it is a very meaningful part of legislation that puts forth in front of this commission whenever the utility is to construct a generating facility larger than 75 megawatts.
Okay. But the certificate issued under a siting act, that's pre-construction, correct?
I believe we do need to get the CPC in, as I've heard it referred to, before construction begins.
Okay. And the siting act doesn't prohibit cost overruns or address changes in fuel prices, right?
Yeah, I'm not aware of what would be litigated in that proceeding and the discussion around those items. I don't know what discussion would actually take place about those items.
But again, in the actual, because you have mentioned the siting act, which we're both familiar with, you would maintain that in that act, in the words of that act, it does not prohibit cost overruns, abandonment, or address changes in fuel cost, right?
I'm not familiar with that section. I can't recall it right now.
Okay. And haven't we learned that company-built projects can have cost overruns even when the utility is acting prudently?
What project are you referring to?
Well, I could talk about 2 holes in the ground in Fairfield County.
Yeah, I'm not sure we're here to litigate nuclear. As I've stated previously, I was not part of that project. I had no responsibility for it, so I can't. I wasn't here for the proceedings other than to talk about customer service and reliability.
Okay. But again, cost overruns can occur even in light of utility acting prudently.
I imagine they could, yes.
Okay. What's the company's total authorized return on investment on VC Summer?
I don't know the answer to that.
Okay. Do you know how many megawatt hours are being produced by units 2 and 3 at VC Summer?
I believe I know the answer.
Can you?
Microphone.
I've been very kind and given Mr. Golden a lot of latitude with his questions about VC Summers Units 2 and 3. As this commission well knows, that issue's been over and concluded by way of a docket last year. And I would ask that you find that these questions are irrelevant and ask Mr. Golden to move on to another subject.
Mr. Chairman, I'm going to have to push back on this. He's opened the door for ratepayer risk. What's being passed along costs the ratepayers. And the company is saying that the longer the term of a QF project, the more rate exposure there is for a ratepayer. All I want to do is establish that those rates actually happen when a company builds a generation plant and can rate base those costs, not us. And so I think it's certainly relevant. And I would ask you to overrule Mr. Burgess's objection.
Mr. Chairman, VC Summer Units 2 and 3 have nothing to do with the line of questionings he just stated that he wanted to inquire about. He's talking about constructing plants in general, and he's certainly happy to do that. But he's asking specifically about 2 units that have been canceled. This commission has ruled on that issue, and we've moved on.
Mr. Burgess, Act 62 was in part passed because of that. And so I think that's what brings us here in part today.
Okay, look, Mr. Golden, I think your point's been made, so let's push on.
Thank you, Mr. Chairman. Mr. Rafferty, you offered testimony that Dominion is not incentivized to understate its avoided costs, didn't you?
Yes, I did.
And you make a claim that it's only independent power producers who have a financial incentive where avoided costs are set, correct?
That's what I said, yes.
All right, so Dominion Energy has shareholders, correct?
Yes, they do.
All right, and Dominion gets no profit or return from power purchases from independent power producers, correct?
That is correct.
Okay, but Dominion does get a return on every dollar they spend on building their own generation sources, correct?
If they're proved to be prudent, yes.
What we just talked about earlier, correct? Okay. And you would agree that Dominion Energy is adopted as its corporate missions that one prong of their goal is explicitly to reward shareholders, correct?
I have not read that investor relations slide.
It wasn't an investor. It's on the motto of your website. But you have to, if you don't have knowledge of it, that's fine what the corporate motto is. And nowhere in Dominion's corporate mission do you mention ratepayer costs, correct?
Nowhere in the motto do I mention ratepayers costs.
As your company, which you represent here today.
I do not know that. I do not know the motto. Sorry, I know our core values. I don't know the motto.
Okay. One of those core values, I believe, that you do know is that your company will reward its shareholders, correct?
I have never read a core value to say rewarding shareholders.
Okay, if you go to dominionenergy.com/company, it's listed on there.
Could you tell me how it's listed?
I just did. So your statement as to lacking a financial incentive here is not in line with Dominion.
Objection, Mr. Chairman, and I'm beginning to think I just need to stand here at the well. Mr. Golden has asked the question, Mr. Raftery has answered it repeatedly, and Mr. Golden continues to attempt to harass the witness with asking the same question, hoping that it's going to elicit a different answer. And I regret to inform him it's not.
That's not true, Mr. Burgess. He changed his answer from knowing the motto to the core values, and so that's why I asked it again. I'm not going to ask it again, Mr. Burgess. You can, we'll go off of it. All right.
Okay, let's. Thank you, Commissioner Belser. All right, I'm gonna sustain. You're gonna move on. When y'all are talking back and forth, address me instead of each other.
Gladly, Mr. Chairman.
Let's keep moving here.
Mr. Raftery, it's a fundamental premise of your remarks that solar has no capacity value because it doesn't contribute to winter peaks, correct?
Yes, I do say that.
Okay. And it follows from that solar doesn't allow the utility to avoid constructing new generation, correct?
Correct.
Consequently, solar doesn't compete with the utility, according to your testimony, correct?
Correct. And furthermore, the settlement agreement, should the need for capacity arise, renewables are expressly identified as a source of generation to be provided a all-source RFP.
Right, and that expires in 2023, correct? So we're talking 2023?
It states that it's in effect through 2023 and that the company can come before this commission and ask that it be removed.
And my client was not a party to that settlement agreement, just for the record, correct?
Is your client part of the South Carolina Solar Business Alliance?
No, we are not.
Okay, then I don't believe they are.
And so back to the line of questioning on solar competing, it follows that Dominion has no financial incentive to discourage QF development, correct?
No, quite the opposite. Dominion is the third largest owner, a subsidiary of Dominion is the third largest owner of solar farms in our service territory. It could be argued that the company should artificially inflate avoided cost rates, as a number of interveners have suggested, so that they could sign more contracts, but that's not the case.
Okay, and thank you. And so it's your testimony there's no incentive to set avoided cost unrealistically low, correct?
Correct, I did state that, yes.
Okay, and solar doesn't insulate ratepayers from risk, correct?
Solar, repeat the question, please.
Sure. Solar doesn't insulate ratepayers from risk, according to your testimony.
Yeah, I'm not sure I talked about insulating risk from ratepayers. There is a risk in a solar farm signing a power purchase agreement and then not actually delivering energy, because that power purchase agreement is taken into consideration in the resource plan. So that is in large part why I understand when you'd asked me earlier about liquidated damages, the importance of liquidated damages being there, and that a solar developer not delivering that energy and the utility being required to procure replacement energy.
And that's due to the lost opportunity cost, correct?
No, I wouldn't characterize it as lost opportunity cost. It is to go out there and procure energy to replace that energy that was counted on in the resource plan resulting from that signed power purchase agreement with the solar developer.
Okay, but all of that stems from the lack of capacity value from solar, what we originally started down this road, correct?
The capacity value or lack thereof in solar is outlined fairly clearly in my testimony, as well as other parties.
Okay. And if solar did have capacity value, the story would be different, correct?
If it actually allowed the company to avoid capacity needs in the future in the resource plan, it would have been assigned an appropriate capacity value.
So it would compete with utility capacity.
I'm not sure that I would say it would compete. Under PURPA and Act Number 62, we would be obligated or required to sign a power purchase agreement.
But both the SBA and the ORS have disagreed with the sentiment that solar does not provide capacity value, correct?
I understand that, yes, and I look forward to that part of the expert witness testimony on it.
Likely. But Dominion has concluded that solar plus storage does have capacity value, correct?
It's intuitive to think that with a storage project it could provide some capacity, but I think it's very specific to the facility itself.
Okay. And you would agree that, I believe in your rebuttal testimony it was, that you said that you disagreed with SBA witnesses Davis' contention that this is a reset. Is that correct?
Correct. In my summaries and in my testimony, I tried to express to this commission the success that Dominion Energy South Carolina has had from the amount of renewables it's interconnected, the amount under power purchase agreement, to include some other projects like net energy metering. So I don't see it as a reset. I see it as a continuation.
A continuation, but you would acknowledge that there's now a mandatory voluntary renewable program for commercial and industrial customers, right?
Which is something that we always could have done before. It is something that we had always negotiated with certain customers, their needs for renewable. Boeing is the best example. I'd further say that in that Commission's docket, we have put forth a variable renewable energy program, and I look forward to having the company witnesses discuss its value.
But before Act 62, there was no law that required that, right?
I don't think it was necessary. The company was already engaging with our major customers on projects like that.
If it wasn't necessary, then why, and again, you personally attended the legislative hearings, why did 36 of the largest and best employers in South Carolina come out and demand clean, renewable energy?
I simply said it wasn't necessary. I didn't say it was a bad thing.
Mr. Chairman, no other questions.
Thank you. Echoplexus, Mr. Witt. Thank you. Mr. Holman. Ms. Ferguson.
Mr. Chairman, members of the Commission. Mr. Raftery, are you familiar with PURPA and its requirements?
I am generally, but as you heard me say before, I'm not an attorney, so.
Is it correct that your title with the company is Director of Rates and Regulatory Affairs for Dominion, South Carolina?
Yes, that is correct.
Do you agree that Section 210 of PURPA was meant to encourage cogeneration and small power production?
I could not. Section 210 sounds familiar, yes.
Did you testify that because ratepayers pay for QF power, the company has no incentive to overstate or understate its avoided costs?
I did say that, yes.
Are you aware that in passing PURPA, Congress recognized that incumbent utilities were reluctant to purchase independently purchased power?
I'm not aware, but I don't dispute that statement, no.
Dr. Tanner talks about mitigation options for the variable integration charge, and that one option is to allow for more flexible QF configurations, such as solar plus storage and flexible solar operations. What steps has the company taken to encourage or allow for that flexibility at the project level?
I think an important thing to consider when you say the project level is what the project is itself. You know, a 1 megawatt battery is very different than a 15 megawatt battery that can provide energy for 4 hours. In company witness Jim Neely's testimony, he describes the differential in revenue requirements methodology and outlines in the associated tariff the necessary inputs in order to develop an accurate and appropriate avoided cost. So to the extent a solar and storage project materializes and presents the company with their specific facility, the company will understand those inputs, what its capabilities are, and provide an accurate avoided cost to that developer of solar or storage.
So your response is that is an example of the steps that the company has taken to encourage or allow for that flexibility at the project level?
Yep, so it is accounted for in the avoided cost methodology. As several of the commissioners have heard me testify in the past 2 fuel proceedings, the company is exploring issuing an RFP for energy storage as part of Act 236's third 1%, and I'm sorry if people aren't familiar with it, but Act 236, the precursor arguably to this, from 2014, promoted through incentives, customer-sided generation, utility-scale generation, and then the third 1%, which was for utility-owned renewables, which could include energy storage. So over the last year and a half, the company's been working on that RFP, and I look forward to it being issued so that we can actually understand the costs and, better yet, understand the benefits it can provide to the system.
Do you agree that storage added to QF projects also have the potential to help with meeting winter peaks?
I certainly think it might be possible, yes.
Do you agree that in Public Service Commission docket number 2018-2E, Order 2018-322, the Commission required the company to investigate and implement economic demand-side management and energy efficiency programs with an emphasis on decreasing the newly developed winter peak?
I am familiar, and I've quoted it in several of my testimonies.
So you agree that that is what the order states?
Without looking at it myself, it sounds accurate, yes.
Did you testify, and you referenced it this morning when you were giving a summary of your testimony, but again, to start over, did you testify that the company has conducted an extensive investigation into the possibility of relying on additional demand response programs to reduce winter peak?
I did indicate that, yes.
Did you testify that the potential study the company commissioned for its pending DSM-EE docket is evidence of that extensive investigation?
It took a year to produce, and yes, it was extensive.
Is it your testimony today that that potential study is evidence of that?
Yes, sure, I do.
Is it true that the company concluded that absent sufficient saturation of advanced metering infrastructure, AMI, on the company's system, no new demand response programs will be cost effective over the 5-year planning timescale used for program planning?
Yes, and that study was actually done by a third party that has been in front of this commission before, ICF International. So it is that study from ICF that the company supports the statement that you just made.
Has the company considered a demand response pilot program for areas served by AMI?
We right now we are finalizing the contracts for AMI. We have not deployed it, so no, we have not.
Did you testify that the company has in fact considered and evaluated potential and existing demand-side management resources and determined that they are not cost-effective to reduce peaks at this time?
I did, yes.
What explorations were done to overcome the barriers that the company perceives and outlines to make these demand response programs feasible?
It's a rather involved answer required to that question. It's one that will be in front of this commission in just a month as we talk about docket 2019-239E. I did not conduct the study. I have familiarity with the results of the study. I think it would be best served for those expert witnesses to describe the outcome of the study. But I stand by the statements that you've asked me previously and now.
Are you in a position to provide any general examples of any explorations that were done to overcome those barriers?
Yep. So certainly from an AMI perspective, and we just established the fact that the company has not rolled it out. We're still going through contractual agreements, and we look forward to beginning that the end of the first quarter of next year, the beginning of the second quarter of next year. The company has explored standby generation. As I understand it, there are EPA air quality issues with standby generators running. We've talked about interruptible load. Today is from an emergency standpoint. Economically, I'm not sure that the study found any to be cost effective. When you do roll out AMI for residential and commercial customers, you can do some demand response where you can talk to the water heater and turn it off, or you could talk to the thermostat. That seems to be the most prudent path outside of installing some standalone items that I don't believe are cost effective.
What new technologies or business models has the company considered to jumpstart winter peak demand savings?
The first step was to do that study to understand what was technically possible and what was economically possible. That was the first step. And as you've asked me and as I've answered right now in the 5-year planning horizon, those don't exist until AMI is rolled out.
Has the company considered working with any third-party vendors to jumpstart winter peak demand savings?
Well, we did. I mean, ICF International, a company that has provided program portfolio analysis. When we initially rolled out our demand-side management programs in 2009, they are a third party that were expressly directed to look at demand response programs to help mitigate the winter peak. So, yes, we have.
That would be the only one third party that you can identify?
Yeah, well, so ICF worked closely with Opinion Dynamics Incorporated. So.
Did you testify that to the extent that additional DSM programs do become cost effective for reducing peak demands, they would serve to reduce the need for additional capacity on the company's system and could also make the electrical system more fuel efficient to operate across peaks?
It sounds like testimony I wrote, yes.
Can the company provide more specificity on the timing of future program plans for demand response?
So the best barometer would be the AMI project. I'd indicated that the end of first quarter, beginning of second quarter next year, we'll start that rollout. It'll take about 3 years to complete 750,000 meters. If there's a time period in there that we feel there's sufficient saturation to implement a program, we will. The nice structure about our demand-side management programs, as this commission knows, is that we come in annually and provide an update as to how the programs are progressing, any additions or deletions. We do that January in each year. To the extent during that AMI rollout, we feel there's that sufficient saturation and that the programs identified in that potential study remain accurate and cost-effective, the company would look to implement them.
Do you agree that the company's proposal outlined in the potential study we've been discussing, proposing 0 new DR within the 5-year program period, beginning implementation 6 years after the 2018 Commission order, and producing a new program impact of less than 1% after 10 years, constitutes the aggressive pursuit of economic demand-side programs that the Commission tasked the company with in the order from 2018?
Yeah, I wholeheartedly do, and if I could, the fuel proceeding in 2018 occurred in April. In June of that year, so less than 2 months later, we started that potential study. And as I have expressed, that potential study took a whole year. there is a process that I look forward to this commission understanding that proceeding about the interviews, the surveys, residential, industrial, trade allies, understanding technically what's possible in the market, understanding economically what's possible, and understanding what customers will actually adopt. That takes a year. It's a very thoughtful process, and it's a process that we've had a number of stakeholders involved, including Mr. Eddie Moore from the Coastal Conservation League. In that entire process, he's been engaged and afforded time and opportunity to provide questions and input that the company took into consideration. So, yes, we absolutely addressed that directive in the Commission's order in 2018. We did it incredibly quickly by starting it probably 6 weeks later, and we have a very thoughtful response to share with this Commission in the docket. And the only last thing I'd say is, we did file that in June, so we've been looking forward to sharing that message with the Commission.
Thank you for that. But just to be clear, you're testifying that the proposal that's outlined in this study that you've deemed extensive constitutes aggressive pursuit.
I do, and as you have quoted, that part of the order says to evaluate and implement cost-effective programs. The study has determined there are not cost-effective programs at this time.
No further questions.
Thank you, Ms. Ferguson.
Thank you.
Mr. Nelson. Thank you. Commissioners, questions? Commissioner Williams.
Thank you, Mr. Chairman. A couple of questions for the panel. How are you all doing today, gentlemen?
Doing fine, thank you.
Good to see you. Mr. Cassius, I'm saying that right. Cassius?
Yes, Mr. Commissioner.
Cassius Clay.
Cassis.
Okay,
Close.
Cassis. Okay, Cassis. All right. Mr. Cassis, in your rebuttal testimony, and I'm referencing page 18, lines 10 through 12, you note that liquidated damages in this context are generally estimated as a proxy amount to compensate the utility for any cost or losses it incurs in obtaining replacement capacity and energy due to a QF's non-performance. And then on page 18 through 19, lines 21 through 2, you state that as a result of DESC's Dominion amended solar avoided costs, Dominion reduced this amount from 55 kWAC to 41 kWAC in its revised filing submitted on September 20th, 2019. You following that?
Yes.
Can you describe the costs and losses that Dominion would experience as a result of termination of the PPA per section 4.2, and why Dominion believes that the $41 kWAC is an appropriate and reasonable proxy of these costs and losses?
Yes, Commissioner. So that provision is actually a formulaic provision. It's a carryover from the PPA, the Purchase Power Agreement, that we've actually filed with the Commission. And so the actual calculation is based on the capacity, it's based on the avoided cost, and it's based on the length of a year, the term, which is what we believe it would take to replace that resource. Granted, avoided cost is low, so it drives the number down lower, which was the change. But we also recognized in the market that it would take approximately a year to replace that resource. So it includes the avoided energy. We believe it reasonably compensates us for opportunities, say, for instance, for another developer to bring in a project who then could essentially reach finance, et cetera, our administrative costs. So that formulaic approach isn't anything different or new. It's the same one we've used on 1,048 megawatts that we've signed or have commercially operated so far.
Okay. Thank you for answering that for me. In your rebuttal testimony on pages 21 through 22, lines 15 through 2, you assert that the QF, can control variables affecting the ability to meet the guaranteed energy production. Can you elaborate on the reasonableness of the provisions that would allow Dominion to terminate the PPA for energy shortfalls?
Sure. Yeah, so we have a production guarantee, if you will, of 85% in that contract. Now, that's the same number that we've used in almost every contract that I think it's 95% of the contracts that have come before the commission. And I think we've had every developer that we've signed a contract with has been able to reach that production level. And unless they have a major issue with equipment or programming of things like inverters. So I think if you don't meet the provision 2 years in a row, which means you're essentially neglecting the asset, then somebody else should have the opportunity to take advantage of providing the resource. That's simply a measure to keep the assets very as reliable as you can get with an intermittent resource is what our expectations are.
Why is termination an appropriate remedy for energy shortfalls occurring in 2 consecutive years rather than relying on performance, liquidated damages, or other remedies?
Well, so here's our experience in the market is that when you put provisions like that, then people actually commit and follow through and do what they're going to say they're going to do in the contract. Now, I think I'm doing this off the top of my head, Commissioner, but the only assets that we've ever had issues with so far of what we have connected, so the 500 or 498 megawatts, the only ones we've ever had issues with, and really we've had 1 year basically of operation on some of those assets, but the only issues we've ever had are they just don't perform. They cause issues on either flicker or inrush or some other issue, and they need to fix them. So it forces them almost to fix them to get back to that threshold that then means we can count on it in a forecast.
Okay. Can you also please describe what analysis or assumptions were used in determining 85% to be an appropriate threshold?
Sure. So the developers actually provide us with their production profile. So there's a schedule or an exhibit in that PPA, and then we don't take the full amount. We take 85%, which provides for some allowance for issues such as equipment maintenance or for weather. You probably are aware that when we have storms or what I would call cloud cover, then those assets don't perform. So it incorporates that. But again, we've used that standard for really the life of all those assets that are under contract.
Okay. Thank you, sir. I'm going to go to Mr. Raftery. How are you doing today?
I'm doing fine, thank you.
Good to see you again. Mr. Raftery, in your direct testimony on page 11, lines 19 through 21, you note that if a utility's avoided costs are calculated correctly and accurately reflect the utility's avoided costs, customers would not be impacted by and would be economically indifferent to purchases of QF power. Do you agree that setting avoided costs correctly will reduce the risk to customers of QF purchases?
We're obligated to set them in that fashion. As I've been crossed by a number of people, they've indicated, what way might gas prices go, up or down. I'm not sure that a power purchase agreement can completely protect ratepayers, but what the company is obligated to do is to put forth its most accurate avoided cost rate based off of the inputs and share it with this commission.
Would you agree that relatively low natural gas prices are contributing to the current levels of avoided costs?
I think they are. I think as well as the amount of solar we have on our system.
Would you agree that the avoided energy cost rate that Dominion has calculated for solar QFs is relatively low?
It is lower than what we've put forth in the past, yes.
This is for either of you, whoever feels best capable or qualified to answer. Section 58-41-2, paragraph F, subparagraph 1 of Act 62 states, electrical utilities, subject to approval of the Commission, shall offer to enter into fixed price power purchase agreements with small power producers for the purchase of energy and capacity at avoided costs, with commercially reasonable terms and a duration of 10 years. Do you believe that solar projects will be able to be financed at the avoided cost that you have proposed?
Commissioner Williams, I don't know if they will be able to finance. I'm not sure that Act 62 says that we need to provide a rate that will make them finance. We have to produce accurate, just and reasonable, fair and balanced rates that are compliant with PURPA and those sections of Act 62 that bring PURPA in. Unfortunately, I can't answer your question whether or not solar developers will be able to finance at our avoided cost rate.
Do you believe that it's important to understand the cost of a solar project and the relationship of these costs to avoided costs as part of understanding the risk associated with solar projects, solar project PPAs, excuse me?
No, I don't feel it's important to understand the costs for the solar developer as it relates to avoided costs. We are expressly directed to calculate avoided costs based off of our system needs, energy and capacity, and that's what PURPA obligates us, and by incorporating PURPA in Act number 62, that's what we're obligated to do.
Do you agree that whether solar projects will be able to be financed with just a 10-year PPA term is an appropriate consideration for the Commission as part of its role in implementing Act 62?
So regarding the term, and Danny, Mr. Cassis might add some additional color. I mean, we have signed contracts with 10-year terms, so.
Recognizing that Section 58-41-20, paragraph F sub 1 of Act 62 states that the Commission may also approve commercially reasonable fixed price power purchase agreements with duration longer than 10 years, which must contain additional terms, conditions, and/or rate structures as proposed by intervening parties and approved by the Commission, including but not limited to a reduction in the contract price relative to the 10-year avoided costs. What would you propose in terms of these additional terms, conditions, and/or rate structures?
Some things that come to mind might be some dispatchability for the solar. We've already put forth testimony that have talked about we have so much solar that is creating challenges on our system, and company witness Hanslick will talk about that. So maybe some dispatchability might be a term that's different from the form contract PPA.
Okay. This is for Mr. Raftery. In your rebuttal testimony, page 2, line 20 through 21, you note that Dominion is agreeable to conducting technical workshops with respect to future changes in the variable integration charge. The variable integration charge that the company is proposing will be used for various PPAs that are already in place. Is that not correct?
Yes. That part of the testimony or the rebuttal was responsive to Mr. Horry's suggestion that the variable integration charge as part of the standard offer be part of a technical workshop to inform the integration study. So my agreement with him is specific to the standard offer. It is not to adjust the calculated variable integration charge to those 700 megawatts of PPAs in effect.
Do you believe that the variable integration charge that you are proposing in this proceeding is a subject of considerable dispute?
It certainly is, yes.
Would you also agree that the issues associated in the analysis, assumptions, and appropriate methodology for establishing this variable integration charge are highly technical?
It is, but from a practical matter, it needs to be understood that that was a term that was mutually agreed to by the seller and the company, and the outcome will directly impact ratepayers.
Given this highly technical nature, of this analysis, assumptions, and methodology, might not a technical workshop be a valuable contribution to reducing some of the areas of dispute?
No, I think that can be resolved as part of this proceeding.
Would the company consider applying this variable integration charge after holding such a technical workshop if we thought that was appropriate?
Yes.
All right, no further questions from me, gentlemen. Thank you.
Thank you. Commissioner Belzer.
Thank you, Mr. Chairman. Good morning, gentlemen.
Hey, good morning.
Good morning.
Mr. Cassis, just briefly, I noted in the direct testimony that you adopted and also in your summary, you made the statement, it should be noted that there are a limited amount of renewable resources that can be accommodated on Dominion's system under current technological and operating characteristics.
That's correct.
Is that a correct statement? Correct reading?
Yes, Commissioner.
Okay. Please tell me what some of those, or what those current technological and operating characteristics are.
Sure. So, and I think, you know, the main thing, or the main point is that renewable energy, specifically solar, it's intermittent. And so that creates a significant challenge. I think the opportunity, I think, is around technologies like storage, whether it be chemical storage or pumped hydro storage. Those then allow for the intermittency, which ultimately drives down the avoided cost. It essentially allows for the more reasonable integration of the resource. So we already see that on our system now with 498 megawatts. We've had plenty of discussions with the South Carolina Solar Business Alliance through stakeholder meetings about expected curtailments based on the next increment of resource that's coming through. We've had substantial conversations with them about storage technology and when that might ultimately become financeable. But that's the direction of that comment.
What should the utility be doing to, in furtherance of PURPA and Act 62, making changes to its system to accommodate some additional resources from renewables?
Yeah. Two things that I think of that right off the top of my head. One is that the real question is PURPA or PURPA QFs, and that way to essentially have a developer put energy on the system, is that the way we should be contracting for resource? Should we be setting a fixed cost, or should we be doing something that's different contractually with a different framework that allows for utilities and developers to, and I'm not making this up, I think it's expansion of that market. I think the way QF solar's done today, in every jurisdiction that's done it, and including our folks to the north, you end up with overpayment in contracts, at least when you do QF solar. So that's one. I think that's a reasonable way to advance the ball. I think the second thing is that we've got to become, we need expertise in storage technology. But you can't do it just in a vacuum. It's also got to ultimately be able to be financed, and you need to be able to quantify the benefits so that that asset either can be financed or ultimately it can be owned by the utility, one of those two.
Thank you. Mr. Raftery, I'm sorry, I've got a bunch of notes jotted down in different places, so I might be jumping around, and I'm going to ask your indulgence.
That'd be fine.
In your testimony and in your summary and also in response to questions, and just for ease, I happen to have your summary in front of me on page 3, and this is the summary of your direct. I'm on lines 10 through 13, and you reference the Energy Information Administration's forms and indicated that the state of South Carolina has more net energy metering installations than the combined total of several states.
I did, yes.
With me?
Yep.
Do those net energy metering installations, does that also include residential rooftop solar?
Yes, it does. That is
That's
a large.
across the spectrum.
It's residential, commercial, and industrial, but the lion's share is always residential.
So that's just not limited to this utility scale that we're talking.
Correct, but I believe the result is the same if you looked at just the residential slice.
I just wanted to make sure that I was reading that correctly. Do you, Mr. Raftery, do you know when Dominion's peak demand switched from summer to winter?
I'm not sure it concretely has switched from summer to winter. My familiarity is that 5 out of the last 10 years it was a winter peak, and 5 out of the last 10 years it was a summer peak. So what I believe company witness Lynch will talk about is the challenge is specifically to the winter peak and those operating reserves that are required to serve the winter peak. And very much in layman's terms, you know, in the summer when your air conditioning is going as fast and as hard as it can, it plateaus. But in the winter, when your heat pump is running continuously, it's always got that extra kicker for heat strips. And that's the kind of exponential challenge with serving the winter peak and the necessary reserves required for it.
How long have you been with SC Dominion?
2003, I hired into an IT area. I ran our call centers and our business offices for 4 years. I ran our renewable group for 4 years, and I've been in this role since March of this year.
So you were there when all the switch was to go to all electric homes and advertising all electric homes and.
It was a little bit before me, but
okay.
Yeah. Yep.
You're smiling too.
Been here 32 years.
Okay. You referenced the settlement agreement in the merger docket and the solicitation for new generation resources.
Yes, yes.
I wasn't here during the merger. Is there a sunset or end date for that provision?
Yeah, the settlement agreement itself states that it will remain in effect through 2023, at which time the company could come before this commission and ask to be relieved from those requirements. There are certain requirements within that settlement agreement that have milestone dates before then.
So the that provision that has been referenced in testimony that the utility will put out for an independent evaluator before building new generation resources and an RFP, that could go away in 5 years or less than 5 years.
It could go away, but it couldn't go independent.
Okay.
We're not the ones that could relieve ourselves from that responsibility.
I believe you mentioned in response to questions from Mr. Golden, a Dominion subsidiary that is the third largest solar developer in this area?
I did, yes.
And does that subsidiary, they operate only in this area, or operate in the southeast or nationwide, or?
They operate across the nation. One point of fact is that Dominion Energy is the fourth largest owner of solar facilities as an IOU.
And so that subsidiary is going out and building solar installations in Dominion's jurisdiction and in other jurisdictions?
At that time, they were acquired and constructed before the companies merged.
But they're still operating?
Yes, they are.
As a subsidiary?
Yes.
I understand there are other subsidiaries doing things, but my questions are, does that subsidiary require a certain term contract before it will agree to operate in or build a facility?
I'm not aware.
Mr. Cassis, do you know?
I'll answer. So the assets that they own, the affiliate owns in South Carolina?
Not just in South Carolina. I'm just talking about before, when they go out to do a project, do they require a minimum term of contract before they will do a project?
Again, speaking for the parent company, but I'm usually a counterparty, but I'll, with them on contracts, I was the counterparty on those original 2 contracts in South Carolina when they were the affiliate. But knowing more about the company, they look at it, they have a financial model where they look at not only the resource maybe in the short term, but on the tail end of the contract, or what could happen on the tail. So it's complex. I mean, when they do the analysis, they do it very similar and operate in the same way that our solar developers in South Carolina do with analysis of financing, spreadsheets, property tax, lease rates. Everything goes into that model to make a determination about what they want to achieve, and including term.
Okay. But is there a minimum term that they require?
Yeah, now I wouldn't know.
I mean, are they saying we're not going to do a project unless we get a 10-year term, or we're not going to do a project unless we get a 15-year term?
I wouldn't know deep enough into their model. I just know in our jurisdiction, those contracts were the early contracts, so they did have some term greater than 10 years. I do know that.
I think that's all I have. Thank you, gentlemen. Thank you, Mr. Chairman.
Thank you, Commissioner Belser. Commissioner Howard.
Mr. Rafferty, you pretty well answered most of my questions on advanced metering, and I think the gist of the conversation was you have upcoming docket, which a lot of those questions would be answered. The only question I have is, you stated the absence of sufficient saturation of AMI. What is your saturation point now, and what do you consider sufficient saturation?
So we have some smart meters deployed. By and large, they're for load research, or they are for the net metered residential systems today. That is not the technology that we will be going forward with as our full AMI rollout. That will be, the first meter should be set in late March or maybe April of next year, and it will take 3 years to complete the electric system, and then those gas meters that are associated with an electric account as well. 3 years is a pretty fast pace to go through our entire system. I mean, you can imagine we're going up to every single home and removing the meter. In just a month, we'll be filing our customer education plan on how we're going to notice customers of that process. Where we get exactly from a saturation standpoint, I don't know a percent or a number of meters, but it would be somewhere logically after maybe the second year that we would be able to further evaluate and roll out a demand response program if it's cost effective at that time.
Thank you. Thank you, Mr. Chairman.
Thank you, Commissioners. Any other questions? Commissioner Whitfield.
Thank you, Mr. Chairman. Just a quick two for the panel here. Mr. Rafferty and Mr. Cassis, thank you for being with us today. Primarily directed to you, Mr. Rafferty, but on this first one, if you want some assistance from Mr. Cassis, please feel free to do so. Like Commissioner Howard, most of my questions were answered, but I want to refer back to a couple of questions my colleague, Commissioner Williams, down on the end had a little earlier for you. And I think one of his last questions to you, Mr. Rafferty, he cited a provision of Act 62, 51-41-20, where it says the Commission may also approve commercially reasonable fixed power purchase power agreements and require additional terms or conditions / rate structures as proposed by intervening parties. And when he asked you that question, he asked you if you had any additional terms or conditions you thought the Commission ought to propose. And one of the things I think you said was a requirement governing dispatching of solar. I think is that correct, Mr. Rafferty?
I wasn't necessarily asking the Commission to approve dispatchability. I was just trying to suggest something that might be different from a solar standalone contract PPA. So dispatchability might be.
Dispatchability, certainly, and you talked, and I think your colleague talked about that as well. One of the things you said, and I'm going to be careful I use the right word, I believe you said in response also to that question from Commissioner Williams, I believe you said there was so much solar on the system, and certainly didn't hear you to say the word too much. You said there was so much solar on the system, and this is where, if you need some assistance from Mr. Cassis, I'd like a little description. When you say so much solar on the system in Dominion's territory in South Carolina, are you seeing that? When you say so much, are you referring to the density in a particular area of solar, or are you referring to rural areas where your infrastructure, such as substations, transmission lines, and all that, are not in place to support it? Could you define what you see as much in an area? Is it density, or is it lack of infrastructure in the company's case?
Certainly where the solar facilities are being located are in the rural areas where there isn't necessarily the load, but there is arguably affordable land. So we do see that. To the extent that a solar developer would cause facilities to need to be upgraded, that's a cost that they would bear. And we certainly have seen some reconductoring that have to take place, as well as some enhancements to the substations in that area. My statement was more general, though, to the entire system that Dominion Energy South Carolina balances. And it was really intended to kind of make reference to the different illustrations that I had in my direct testimony that talks about when you have 1,048 megawatts on a system that averages 42 or 4,300, it causes your system to behave very differently. And equally important, these system operators are going to have to respond very differently. Specifically, if you could picture, like illustration 4 shows 1,000 megawatts of solar on the system on a shoulder day, and that peak that occurs, in the early morning and the evening, and how low the net system load gets in the middle of the day, that is a challenge, and Mr. Hanslick will be discussing that.
You have anything to add?
Yeah, so not to tell you what John's testimony says, but I think we both know this, having worked in the industry. So QF solar, is ultimately, at least what we've seen in our market, the first adoptions were built on very cheap land, so you could get a land lease. You needed to get property tax relief, so some fee in lieu of agreement, and then you needed a cheap interconnection. But it wasn't necessarily built where it would be best integrated or where the load was. So if you think about the middle of the state where it's nice agricultural land, where they might prefer to put a generating asset instead of an agricultural use, that's where we saw the initial adoption. And I think the challenge is that most of the load is on the coast, or it's in these much more dense urban areas like Columbia. And that's the challenge with integrating an intermittent resource is QF solar isn't necessarily the place where it's best for the consumers in the end.
And I appreciate your reply also, Mr. Cassis, and I realize that Mr. Hanslick is up next and going to delve into that a little further, so I'll leave that alone. Lastly, Mr. Raftery, I think you said to Commissioner Williams, you acknowledged in the question before that, you had said that the company had signed some 10-year contracts, and I just want to kind of follow up on what that question was. As I heard Commissioner Williams, he just said, do you agree whether solar projects will be able to be financed with just a 10-year PPA term is an appropriate consideration for the Commission as part of its role in implementing Act 62?
So I don't know how many 10-year contracts we've signed, but we have signed those contracts. I think that's reflective of the amount of solar that we had signed under longer-term contracts and some of that, the risk that is associated with signing a contract at a higher avoided cost. When we first signed those contracts, avoided costs were in the $40 per megawatt hour range, and as we know now, so the prices decrease. So arguably, ratepayers, are in a 20-year term at a higher number. I think 10 years strikes the right balance, and Mr. Cassis might add to some of the questions about term.
Yeah, I think we had the benefit of maybe seeing the way development took place in other states that were contiguous to us. Sometimes it's an advantage not to go first, but to go smart. So I think in other states, and particularly in North Carolina, there were higher valued QF contracts, must-take contracts. And so I think in North Carolina, after review, they've determined that now currently those long contracts are also contracts of overpayment. And so in the end of the day, those costs shift in the fuel supply, those costs shift to the consumers. So although we do have some 20s and some 15s, we recognize that maybe the contract should be shorter to offset some of that risk. And then what happens with that asset in the latter part obviously can be reflected more properly with what the resource is worth.
Well, thank you both for your answers, and that's all I have, Mr. Chairman.
Thank you, Commissioners. Any other questions? Commissioner Urban.
Thank you, Mr. Chairman. Gentlemen, thank you for being with us today. Just to follow up on the response that you gave, Mr. Rafferty, about the rollout of the advanced metering infrastructure as a way to provide cost-effective demand response. Why can't Dominion go ahead with expanding programs like direct load control or smart thermostats or water heater switch-offs? Wouldn't those provide some winter peak shaving without the need for AMI meters?
I believe that those programs, absent an AMI technology having been rolled out, are not cost effective. So you certainly, through some technologies, can put individual collars and disconnection devices on heating and cooling units and water heaters and as such, but when you evaluate the cost versus the benefits, they don't pass the test. Once AMI is rolled out, there is the ability to leverage that AMI network, and those programs will pass cost effectiveness.
Do you have studies that you mentioned a study? Did it delve into the details of those costs?
It certainly delved into the analysis. I'm trying to remember in the document that might be close to 200 pages how much it conveys of the cost. I'm certain if the costs aren't in the study, they are in the model and can be produced.
Would a pilot be beneficial in say, further evaluating those projected costs?
With the AMI project, I think so. I think the challenge will be in how you market these programs and how you perform the AMI rollout. So there are some considerations for, do you go into a certain pocket and get it done very quickly, say Lexington or Columbia or what have you, and then do you roll to the next area? I think that provides some implementation challenges because when you do it that way and you get a contractor to help you, he or she doesn't want to move around the state. So there might be some benefit where you have multiple swim lanes going on where you're doing the Columbia and surrounding areas for 2 years and you can maintain continuity of the contractors. Meanwhile, there might be an overlap with Charleston and you're doing it for 2 years to get the system completely out. You run into some risk with resources if you just try to jump in and out of areas very quickly. And so that, I think, plays back into the marketing and how you would market to certain areas. And so it's an important consideration into when we could pull the trigger and actually do that.
So you will still consider that, perhaps?
Absolutely, yes.
Okay, that's good. Does the company have its own research and development staff and when it gets into the technical aspects of all this? Or do you rely on third parties to provide it?
Specifically for demand side management and demand response programs, we have an in-house staff of about 20 people that actually report into Mr. Cassis. They used to report to me prior to this role. They have industry expertise. They have relationships with trade allies. They interact with the customers every day. When you expand beyond demand side management or demand response and how it's augmented with third parties and other experts, and you get into energy storage, we've got very technical power quality people that are working on some of the solar projects issues that we've had that Mr. Cassis referenced, but they're also attending conferences, talking with peers in neighboring states, talking with vendors to understand, what are the capabilities of things like different chemistries within lithium-ion batteries, for example.
Do you think it might be advantageous if you expanded the R&D component to keep up with the changing technology like storage?
I look forward to that RFP on energy storage. I think that it will be an ideal opportunity for us to learn how energy storage behaves on the system. It is a targeted pilot. I mean, it is arguably about 40 megawatts of energy storage. And you may remember from the fuel proceeding, I also articulated the potential at our Lake Murray Research Center developing a microgrid application where you can balance both the load and the supply, a combination of solar and storage with that load. So those demonstration projects, I think, are the prudent next step in evaluating that.
And you probably have plans for a pilot storage project in South Carolina?
Yeah, and so that's what that RFP would do. It would be to concretely get bids in, understand what the prices are. We would have to come back to this commission for approval of those programs. We would need to convey both the costs and what we perceive the benefits and what we intend on learning through the pilot.
Excellent. I keep reading in the media about how artificial intelligence is going to help corporations like Dominion solve complex problems. Are you looking at that as a way to invest in your R&D?
The company, Dominion, has, I think this is actually the second year that we've continued with an innovation theme where they have these spark tanks where groups can propose innovative ideas in their area, and they go through almost Shark Tank kind of competitions where they pitch their innovative artificial intelligence related what have you idea, and as they pass certain gates. So we had one here in Casey. We sent 2 people to Richmond to compete against peers that came from Ohio, Utah, Virginia. It's all under this innovation umbrella. So it is something that the company's embracing a great deal.
I'm pleased to hear that because the technological advance, I think, is staggering, and we're going to, in order to stay ahead of the situation and to just try to start to address climate change solutions, that's going to be an important part of the equation, don't you think?
I do.
All right. And finally, the real question is how quick are we going to get to a storage solution? Do your experts have a thought about that? Because that impacts other things like whether or not to build a new natural gas facility.
Yep, I'd be happy to give you my opinion.
Yes, sir.
So solar panel prices were dropping about 10% every year based off of improvements they've made in the technology and the manufacturing process. Energy storage has been following a similar trend over time. Maybe it's not 10% reduction every year. The fact of the matter is energy storage is not cost effective right now, but if it continues that trend like solar, it might be there. I think many of the conversations around energy storage are the use case. And so what we've been talking about often is lithium ion and the ability to move energy from hour periods. So we talk about 1 hour, 2 hour, 4 hours, and arguably you could move it from day to day. But what might be the panacea of change in the electric industry is the ability to move energy from week to week or month to month or season to season. That, I believe, in my research and talking to others, is a different chemistry than lithium ion. It is something different. It might be a flow battery, but that's where, if you ever hear a company be a little hesitant from a mention of zero carbon emissions, it's because the technology is not in place today to get you there. I mean, there are certain technologies that are improving, that people are developing use cases and implementing it, but the big energy storage solution's not there right now.
So if you had to put a time window, if you're asked to do that, you're saying be here in 5 years, 10 years?
And I would, and then people would tell me cut it in half. And then
So it's
technology
probably going to
advances.
come sooner than we expect.
I think so.
All right. And it would be a great opportunity for Dominion and other investor-owned utilities to be on top of those changes and invest in them and employ them as soon as possible.
To provide reliable reliable service to our customers, yes.
Thanks, sir.
Thank you, Commissioners. Any other questions? Mr. Burgess, any redirect?
Mr. Raftery, Mr. Golden asked you a little bit about Act 62, and in your direct testimony, you stated that the General Assembly is encouraging renewable energy resources. Is that correct?
Yes, I do.
And is it not true that in this proceeding, is only limited to QFs with respect to solar? Is that correct?
Yes, correct.
And isn't it true that in Act 62, there are other mechanisms in the Act that encourage renewable energy? Is that correct?
Yes, there are other sections.
And for example, isn't it true that net metering is included in Act 62?
Net metering, yes, it is.
And that would be a way of promoting renewable energy.
As is community solar, the voluntary renewable energy program. There are a number of different sections, yes.
Thank you, Mr. Raftery. Mr. Williams also asked you, Mr. Williams asked you about the variable integration charge. And isn't it true that in the 2018 fuel proceeding, Dominion Energy presented a variable integration charge?
It did, yes.
And isn't it true that the Solar Business Alliance asked this commission to bifurcate that issue from that proceeding and address it in an Act 62 proceeding?
Yes, and did you say 2018 or 2019?
I misspoke, thank you. 2019 proceeding.
Yes, that is true.
And with respect to the variable integration charge, Mr. Cassis, that charge currently is set forth in existing purchase power agreements. Isn't that correct?
That's correct. That was a negotiated contract. I think it's in about 700 megawatts of those contracts agreed upon between the buyer and the seller.
That's a great point. You didn't force the solar developers to enter into a contract that contained a variable integration charge. They did so on their own volition. Is that correct?
I did a lot of discussion with developers over that term.
And
we did discuss it.
They understood that.
We absolutely discussed it. It was clear. It was in there.
And they signed those contracts of their own free will.
I didn't sign them for them.
Commissioner Belzer, Mr. Cassis asked you about some Dominion Energy-owned solar projects. Isn't it true that when Dominion Energy actually purchased those contracts, purchased those facilities from existing solar developers?
Yeah, they did. They were a developer. A developer actually essentially contracted for, signed the PPA with me. They then bought those assets upon COT, upon closing.
And the Dominion Energy affiliate company did not negotiate the terms of the PPA. Is that correct?
That's correct.
And isn't it true that when Dominion Energy purchased those facilities, they assumed the contract that was then in existence between Dominion Energy South Carolina and the solar developer?
That's correct. They took the good and the bad with it. Yeah.
Mr. Raftery, there was a couple questions with respect to a 10-year PPA. And you stated earlier you're familiar with Act 62, correct?
Yes.
And I'm going to show you a provision here in Act 62, if I can get the Elmo to come on. And admittedly, Mr. Chairman, I do not possess the skills to operate this Elmo. Yeah. So somebody, if Randy might be able to help me. Oh, perfect, okay.
Ask Scott Elliott, he knows how.
Yeah, precisely, yes. Mr. Raftery, this is section 58-4120 F1 of Act 62. Would you read the first sentence before the underline?
Electrical utilities subject to approval of the commission shall offer to enter into fixed price power purchase agreements with small power producers for the purchase of energy and capacity at avoided cost with commercially reasonable terms in a duration of 10 years.
And it is true that Dominion Energy South Carolina has presented a form PPA as well as a standard offer that includes a term of 10 years. Is that correct?
Yes.
Would you please read the second sentence as underlined as well?
The Commission may also approve commercially reasonable fixed-price power purchase agreements with the duration longer than 10 years, which must contain additional terms, conditions, and/or rate structures as proposed by intervening parties and approved by the Commission, including but not limited to a reduction in the contract price relative to the 10-year avoided cost.
And isn't it true that under the section that you just read, that interveners possess the duty and obligation to propose a rate structure if they wish to have a PPA of greater than 10 years?
Yes, that's what Act 62 says.
And isn't it true in the merger proceeding that Dominion Energy South Carolina entered into a settlement agreement with the Solar Business Alliance in which the parties agree, in which Dominion and SBA agreed that Dominion would present PPAs with a PPA term of not less than 10 years?
Yes, that's what the parties agreed to.
No further questions, Mr. Chairman.
Thank you. Based on those questions, is there any recross? I need to get to a microphone that's on.
This goes to the questions, Mr. Chairman, thank you. This goes to the question that Ms. Belser asked about the term length for the unregulated affiliate that you guys have. I'm just looking at your...
Mr. Chairman, I'm sorry to interrupt
Yes.
Mr. Adams, but I'm unaware that after we engage in redirect, that other parties get an opportunity to re-cross-examine our witness.
That's very true. It needs to be with one of the questions that came in redirect.
All right, well, my only question would be as to what Ms. Belser asked about.
Okay, we probably passed that.
All right, I'm good then.
Thank you.
Thank you, sir.
Okay. Anything else for these? Any other recross? Okay, if not, gentlemen, thank you for your testimony. You may step down. Dominion, if you'll call your next panel. We're going to 12:30, so.
Mr. Chairman, Dominion would call to the stand Mr. Eric Bell and Mr. Thomas Hansley.
Gentlemen, if you would raise your right hands, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Let's begin with Mr. Bell. Please state your name for the record.
My name is Eric H. Bell.
By whom are you employed and in what capacity?
I'm employed by Dominion Energy South Carolina as the Manager of Economic Resource Commitment.
And in connection with this proceeding, have you prepared a cause to be prepared under your supervision, certain direct testimony that's been pre-filed in the record here of 22 pages?
Yes.
Are there any corrections to that testimony?
No.
And I understand there are no exhibits to that testimony. Is that correct?
Was that, Bell?
No exhibits to that testimony.
No, sir.
Correct. If I were to ask you the questions contained in that pre-filed testimony, would your answers today be the same?
Yes, they would.
I would move the admission of Mr. Bell's direct pre-filed testimony into the record at this point.
Mr. Bell's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Mr. Bell, have you prepared a summary of that testimony?
I have.
Would you please give that summary to us?
Yes, I will. Good morning, Chairman Randall and members of the Commission. In my direct testimony, I discussed Dominion Energy South Carolina's experience in managing its energy supply with significant amounts of photovoltaic solar generation facilities, or solar, interconnected with the company's system. I also discussed the data and other inputs derived from this operational experience. The company provided these data and inputs to Navigant Consulting for use in the cost of variable integration study, which Mr. Tanner presents here.
Bill, if you could move the microphone a little closer, that might help also.
Solar panels convert light directly into electricity. Therefore, the amount of sunlight falling on a solar facility at any given time dictates its electrical output. For this reason, solar generation produces electricity independently of instructions from our system control center or customer demand. On days of low solar production, the company's other generation resources must also deliver additional output needed to meet customer demand. Also, within a given day, unforecasted changes in weather result in unplanned drops and increases in solar generation that the generating system must absorb. Weather that fluctuates between cloudy and partly cloudy may create changes in utility scale solar generation of hundreds of megawatts. Once those changes begin, they may unfold in unpredictable ways over many hours. This increases the balancing ramps required from dispatchable generators. The company recently experienced a significant increase in solar generation. As of August 2019, the company has a total of 511 megawatts of generation in commercial operation on its system. In addition, developers representing another 12 large solar facilities have executed power purchase agreements with the company. These 12 facilities are expected to enter commercial operation between now and the end of 2020. By the end of 2020, Dominion Energy South Carolina expects to have a total of 1,152 megawatts of solar facilities connected with its system. This represents about one quarter of our current peak demand, a significant amount. Supporting this scale of solar generation creates real-world challenges. The company must be in position to meet those challenges to safely and reliably operate its system and comply with the mandatory reliability requirements monitored and enforced by FERC, the Federal Energy Regulatory Commission, and NERC, the North American Energy Reliability Corporation. And the uncontrollable factors which affect solar generation, such as available sunlight and cloud cover, mean that a solar facility's output is not necessarily predictable or responsive to system needs. Therefore, the company must make operational adjustments to respond to the variable output from solar facilities. After making those adjustments, the company must ensure that it still has sufficient reserve generation capability to meet system reliability requirements. In short, the constant variability of solar generation, as well as the wide discrepancy between solar generation forecasts and actual generation, create a need for operating reserves. At times, solar generation can be forecasted with some certainty. At other times, the amount of energy generated does not meet forecasted projections, and the shortfall must be supplied by another source. Baseload units like coal-fired steam units and combined cycle units require from several hours to 2 days or more to provide load or reserves, especially if they begin in an offline condition. Accordingly, the company's system control must prepare for the unexpected loss of solar generation well ahead of its possible loss. This may mean keeping thermal units online but lightly loaded in case they are needed in short notice. This can be costly from a fuel efficiency standpoint. Further, the company may need to commit operating reserves or other generation units to produce the power to meet shortfalls in solar. Once committed, these units no longer count as operating reserves, and other operating reserves must be identified. The company must meet its reserve requirements through all changes on the system, including those caused by solar. The company must have generators available or online that are capable of producing electricity quickly and reliably to meet its reserve requirements. Dominion Energy South Carolina maintains several categories of reserves. Contingency reserves must be supplied on demand within 15 minutes and include spinning and non-spinning reserve requirements. Spinning reserves are provided by generators that are already online but not operating at full capacity. Those units can immediately generate additional electricity to serve the load. Non-spinning reserves may be supplied by both online and offline generators that can be fully loaded within 15 minutes. So the company's combustion turbines and Saluda Hydro are already used extensively as reserves, contingency reserves. The only way to increase reserves available from them is to construct additional units. Creating additional reserves by holding back generating capacity at Fairfield Pump Storage is expensive because it adds fuel costs to the systems to the system in most circumstances. Furthermore, the company can increase its reserve by operating more coal and gas-fired baseload units at minimum load levels. However, this will require the company to operate them in a manner that's less efficient and more costly. In short, maintaining additional reserves is expensive. In my direct testimony, I include 6 graphs that illustrate the actual and varying levels of output from utility-scale solar generators on the Dominion Energy South Carolina system. This data was selected from actual days in 2019 to emphasize characteristics of what the company experiences on its system. Each chart displays actual combined solar production from 27 to 30 utility-scale generators on the company's system. Although a typical solar output characteristic exists and is recognizable, it is important to see that irregular production is common. These irregular days are impossible to forecast with a high degree of accuracy. In my testimony, I also discussed the Navigant study. In September of 2018, Dominion Energy South Carolina employed Navigant to study additional costs imposed on the system due to the intermittency of solar. The company supplied input to Navigant, including load and system resource data. The company also provided solar energy profiles from actual solar installations with energy production from 5 geographic areas in the company's service area. In the study, Navigant provided findings about the intermittency of solar on the Dominion Energy South Carolina system. It found that drops in solar are difficult to forecast and can cause large deviations from the generation forecast. These findings confirm that the company must anticipate and plan for significant variations from the solar forecast. The company must maintain adequate reserves to balance the load in the face of that variability. In 2019, the company requested that Navigant refresh the cost of variable integration study, or VIC study, and supplied an updated schedule of solar projects expected to interconnect with its system under the signed PPAs. The study analyzed the impact of actual amount of solar interconnected prior to 2018 separately from the utility scale solar expected to be interconnected with its system by 2020. This two-part structure allowed Navigant to focus its study on calculating the VIC costs for the 700 megawatts of PPAs which have integration cost clauses in their contracts. These clauses are intended to allow the company to charge these costs to developers rather than looking to collect them from the customers. This concludes the summary of my direct testimony.
Mr. Bell, have you also prepared the cause to be prepared under your supervision certain rebuttal testimony that's been pre-filed in the record?
I have.
Of 14 pages.
I have.
Excellent. And are there any additions or corrections to that testimony?
No, there's not.
I understand also there are no exhibits to that testimony.
That's correct.
If I were to ask you the questions that are contained in that pre-filed rebuttal testimony, would your answers today be the same?
Yes, they would.
Mr. Chairman, I would move the admission of Mr. Bell's pre-filed rebuttal testimony into the record.
Mr. Bell's pre-filed rebuttal testimony will be entered into the record as though given orally from the stand.
Now, Mr. Bell, have you prepared a summary of that rebuttal testimony?
Yes, I have.
Would you please give us that summary? Yes, ma'am.
Is there a prepared written summary to give out on this?
There is. Has that not?
No.
Let's take a minute and be.
We have the rebuttal?
We got the direct, but.
We got the direct and we got Mr. Hansley.
And we got the direct of Hansley.
Thank you. My other question is, have these summaries been provided to the other parties?
Also,
No, they have not.
I don't believe they have. We prepared them as a talking points for the witnesses. The witnesses may well change the summaries as they prepare them. We did not.
I don't know that we can receive them if the parties don't receive them.
That's the point. So we have copies here. We'd be happy to circulate them.
Thank you.
Okay, we got everybody with everything they need. Okay, let's go forward.
See, apologies for the confusion there. Mr. Bell, could you please summarize your pre-filed rebuttal testimony for the commission and the parties?
In my rebuttal testimony, I addressed issues raised by witnesses Mr. Horry, Mr. Stenklick, and Mr. Burgess. I first respond to Mr. Horry's concern that the Navigant study overstated reserve needs by holding reserve levels constant throughout each day of the year. Specifically, I explained that in daily generation planning, Dominion Energy South Carolina uses an hourly profile for operating reserves based on the VACAR Virginias and Carolinas Region Reserve Sharing Group, contingency reserve requirements, and additional operating reserves for the hour-by-hour solar generation forecasts by the company using detailed forecast weather data. I confirmed that Navigant made an appropriate adjustment to the VIC calculation to adjust for the difference between constant reserves and lesser amounts needed on 62% of days modeled. I therefore conclude that Mr. Horry's suggestion to reduce the proposed VIC to apply to certain PPAs is without merit, and the proposed VIC should not be reduced. With regard to Mr. Horry's opinion that it may be appropriate for Dominion Energy South Carolina to use solar drops over a shorter time frame than 15 minutes, I explained that the 15-minute block is simply too short a time period to assess the full impact of solar intermittency on operations. Short drops of 15 minutes are addressed with regulating reserves, and the use of contingency reserves to cover short-term intermittency is inconsistent with actual operations in compliance with balancing standards. Existing data shows that solar drops occur incrementally and unpredictably over many hours. Analyzing data for timeframes of 1 hour to 4 hours may be required to ensure reliability. It is not reasonable or appropriate to analyze contingency or operating reserves using periods of less than 15 minutes. I also testify that Mr. Stenklick's suggestion that the Navigant study assumed improperly high reserve requirements is incorrect. Dominion Energy South Carolina's actual operating practice requires reserves equaling 40% of actual or forecast solar output to account for solar intermittency. This is in addition to contingency reserves, which are a different form of reserves entirely. The 40% flexible reserve allows the system to respond to solar intermittency that exceeds 15 minutes and still maintain the operating reserves to respond to the largest thermal unit in operation at that time tripping offline. Also, because the probability is significant of a coincidence of a thermal unit's forced outage and a large unplanned drop in solar generation persisting for hours, I explained that prudent operators must consider and plan for both contingencies to happen together. Therefore, reserves for solar intermittency must be in addition to the existing contingency reserve requirement. Using current experience as a basis, additional reserves of less than 40% would be imprudent and expose our customers to unacceptable risk. I also testify that Dominion Energy South Carolina uses hourly forecasted solar production as well as actual solar production to plan and maintain reserves on an hourly basis for real-time system operations. This limits the additional reserves for solar and the associated cost to daylight hours. I then explained that any assertion that Dominion Energy South Carolina failed to evaluate less costly methods of integrating low-cost renewables resources is incorrect. In fact, the company and Navigant have compared the cost-effectiveness of reserve resources, alternative reserve resources such as batteries and combustion turbines. However, the fixed cost of these resources is higher than the carrying costs of carrying additional reserves from existing units. Mr. Burgess states that a VIC should not be established until an independent integration study is completed. In my testimony, I disagree, and I present several reasons to proceed with the VIC. Over 500 megawatts of utility-scale solar facilities have already been interconnected with the system and are resulting in additional costs. Those costs should be recovered from the energy providers as the contract clause allows. Both the company and the solar developer agreed to the terms of the contract and knew the adder was being contemplated. Soon another 700 megawatts of solar with the same technology, VIC clauses, and integration requirements will be operating with additional costs going to customers. I also explained that the Federal Energy Regulatory Commission monitors the company's compliance with certain balancing area standards and the maintenance of contingency reserves. I also note that solar generation impacts compliance for most reliability standards, and FERC has the authority to administer significant fines if Dominion Energy South Carolina does not meet the electric reliability organizational requirements. This concludes the summary of my rebuttal testimony.
Thank you, Mr. Bell. I'll now turn to you, Mr. Hanslick. If you would bring your microphone forward and turn it on. Please state your name for the record.
Thomas E. Hanslick.
By whom are you employed and in what capacity?
I'm employed by Dominion Energy South Carolina as manager of system control.
Have you prepared or caused to be prepared certain rebuttal testimony of 21 pages that has been pre-filed in the record of this proceeding?
Yes.
Are there any corrections to that testimony?
Yes, I have 3 corrections. On page 9, line 20, the date changed from August 22nd to August 4th. On page 10, the graph, the line reflecting system load is from August 22nd, not August 4th. The other data is August 4th data. And I believe we have copies that we can hand out.
Yes, we do. Okay. I'll handle that in just a second.
Okay. And on page 10, line 5, the number 150 megawatt, the number should be 50 megawatts. So the sentence should read, then over the next 3 hours, solar generation increased by 300% to 150 megawatts as load decreased, before decreasing by the same 300% to 50 megawatts by late afternoon.
And Mr. Hanslick, I understand there are no exhibits to your testimony. Is that correct?
That's correct.
If I were to ask you the questions in that pre-filed testimony today, would your answers be the same as corrected?
Yes.
I would move the admission of Mr. Hanslick's corrected pre-filed rebuttal testimony into the record.
Mr. Hanslick's pre-filed corrected rebuttal testimony will be entered into the record as though given orally from the stand.
Mr. Chairman, one matter we took up in the break, because the corrections to the graph that Mr. Hanslick had could not be fully expressed verbally, we have a replacement copy of that, which is identical to what is on the going to be presented on the screen. In addition, he will be referencing specific megawatt numbers at the peaks and valleys on this, and so he's labeled those on the graph. I've given copies of that to the other parties. I understand there's no objection to adding them to the record, so the record reflects the document Mr. Hanslick is speaking from. I would ask that document to be entered into the record as the next hearing exhibit.
No objection.
Okay, any other objections or non-objections? All right, we'll add this document as hearing exhibit number 3.
Mr. Hanslick, before I ask you for your summary, I'm going to give you the clicker. And understand the second time you click it, the megawatt numbers will show up on these slides. So now, have you prepared a summary of your rebuttal testimony?
Yes, I have.
Would you please provide that to the commission and the parties?
Good afternoon, Chairman Randall and members of the commission. I did not provide direct testimony in this docket. However, I recently submitted rebuttal testimony. In my rebuttal testimony, I discuss my actual operational experience as manager of the company's System Control Center, as well as my experience dispatching generation to meet customer demand in a reliable manner that complies with mandatory reliability standards. Specifically, I respond to assertions made by Mr. Stenklick relating to the company's need for operating reserves and the company's options to respond to operational challenges associated with intermittent or variable solar generation. The System Control Center is a transmission system control center in which the company monitors and controls its transmission system and dispatches its generation fleet to reliably meet customers' load in real time. The System Control Center's primary function is to maintain compliance with regulations that govern the bulk electric system and to ensure safe and reliable electric service to our customers. Doing so requires us to plan for, anticipate, and respond to events such as changes in system load, unexpected equipment outages, generating facility trips, and other system-related events to ensure reliability and minimize risk within our balancing authority, or BA, as well as risk or impact to the Eastern Interconnection. To promote the reliability of the U.S. energy grid, Congress provided the Federal Energy Regulatory Commission, FERC, with authority to levy penalties up to $1 million per day per violation for violations of mandatory reliability standards, among other things. FERC named NERC as the lead organization to ensure the reliability of energy delivery by developing and enforcing mandatory reliability standards. Real-time operations of RBA require operating reserves to balance Dominion Energy South Carolina's load and generation at all times in order to maintain system reliability and compliance with the BAL standards. Operating reserves are calculated daily to ensure the generating capacity is available to balance load and generation as load increases from its minimum level to the maximum peak hour of the day. Until recently, the challenge of balancing our system in real time has been limited to the diversity of loads: lights, heating, air conditioning, electronics, appliances, manufacturing equipment, and pumps and fans, among others, and outages of traditional generators within the Dominion Energy South Carolina BA. However, with the addition of solar generation and the intermittent production associated with this resource, there is a need for increased operating reserves specific to solar generation to maintain compliance with the BAL standards. Operating experience shows that it cannot be reliably predicted when solar panels will either reduce or increase their output, and therefore we must factor into the variable and significantly unpredictable operating characteristics of solar generation as a factor affecting reliability. I have provided 2 graphs with my summary illustrating specific examples of solar variability in DSC's recent experience. And I'd like to go up to the screen to walk through these
That's fine.
graphs. Okay, can you hear me?
Speak loudly.
So what I put together here is a graph of what we experienced in the control room on August 4th. And I'd like to kind of walk you through it just to show what the controllers working that desk that day experienced and kind of give you some ideas how they responded to it to maintain the NERC reliability standards associated with BAL 1 and BAL 2. First of all, this orange line is the load curve that we actually had for the day. We're starting to graph about 7 o'clock in the morning when solar starts to increase, and we ended about 8 o'clock in the evening. So as you can see, our load curve is and by the way, our load curve is, the scale is on, oh, that one good.
Don't touch the screen.
It's on this side right here.
Go crazy.
So this is the scale for load. So we're peaking at about, let me see if I get this. Okay, so we're peaking at 3,446 megawatts for the day. The orange line here is our solar forecast. This is what we were forecasting for the day for solar. And the blue line is what we actually experienced. So when the sun came up, the blue line actually, the actual solar was a little bit ahead of the forecast, which is.
I believe you need to go back one there.
Oh, okay. So the actual solar is a little bit ahead of forecast, and it peaked at 293 megawatts around 10 o'clock that morning. And shortly after that, it just started to decay. And during these times when we see a fairly large increase or decrease in the solar output, then it flattened out a little bit, it decreased again, come back up, flatten out, and decrease until we got to a low of about 40 megawatts around 1:30. During this time, the controllers on the desk, first of all, when you see a decrease and then it flattens out, you wonder if that's it. Are we going to be there, or is it going to continue to decrease? Will it come back? It's just totally unpredictable. So during this first phase here, we had regulating reserves that we were able to follow that load. Follow the solar curve to balance our load and the generation. So we increased those units. As it further decreased, we continued to ramp generation up, use our regulating reserves to keep up with it until we bottomed out here. And it stayed down for about 2 hours, here to here. And then it started to increase again. So just as we were feeling comfortable balancing the system at this level, the solar generation increased to about 210 megawatts. So from 40 to 210. And immediately pretty much turned around with much variability until it bottomed out again at 56 megawatts. We relied on our reserves during this time to balance the system and remain compliant. One of the questions is, why wouldn't you make purchases to get through this time? And the problem was we wouldn't know when to make a purchase. If we decided we were going to make a purchase here, then we have the purchase covering this load, and solar increased again. So now we balance our system with our ACE, the area control error. That would shoot a high positive number of ACE, which would put us into a non-compliant zone with the BAL standard. I've got another graph here, another curve, September 9th. Now this was a pretty high load on our system. We actually had 4,459 megawatts at 3:14 p.m. Again, the day started out with solar slightly ahead of forecast. It peaked out at 309 megawatts and just continued to slide throughout the day. And during that slide, there's much intermittency, variability in how we would balance during these times right here. Again, this was the time where we used our regulating reserves, our operating reserves, to cover this deficiency in the actual solar compared to what we forecasted for the day. So based on this experience, system control counts 60% of forecasted solar across the peak hour as reliable power and considers 40% to be at risk. Dominion Energy South Carolina must therefore maintain reserves to support this remaining 40% of forecasted solar output, which is not counted on for reliability purposes and is assumed to be generation that could be lost. The reserve number is more likely to increase as solar generation increases within the Dominion Energy South Carolina BA. This concludes my summary.
Thank you, Mr. Chairman. Members of the Commission, the panel is available for cross-examination.
Thank you. Panel, we're going to take a break, so you'll remain under oath. During lunch, we'll give you plenty of time for lunch. Based on this morning, you probably ought to get a takeout. It'll last you till tonight. We will come back from lunch at 1:57.